Good morning, good morning, good morning, Law Nerd. It's Tuesday, it's March 4th. Can I believe it's March? No, I can't. Can you believe it's March? Probably not. How did we get here? But we are on the countdown to the Karen Read trial. And in the run-up to the Karen Read trial, there are going to be a lot more court hearings. Today, there is a ton on the docket for the judge. And the judge set aside this week, Tuesday, Wednesday, and possibly Friday for hearings. But that included the motion to dismiss. Well, based on more discovery turned over by the Commonwealth, the defense has asked to continue the argument on the motion to dismiss so that they can file a supplement. But still on the docket are at least two pending motions that have been pending for a number of weeks now from Mr. Alessi to exclude the experts from the Commonwealth. Remember, they've got like a dog behaviorist that's going to talk about a dog bite, but when it was the ARCCA witnesses, the court's like, only a medical doctor, that motion. So there's two motions regarding the Commonwealth experts. Then we've got the Commonwealth motion for sanctions. We've got that defense motion to dismiss. So we've got just a day full of motions today, possibly into tomorrow. But tomorrow we'll be starting later because the defense will be in federal court in the morning. No, that's not streamed. No, there's no audio. That will be they will be in federal court tomorrow covering the habeas petition. There will be argument on that, and then they will come to court. I imagine they'll be in court after lunch. So 1 o'clock Eastern is my guess tomorrow, but we'll see what happens. So this morning, we're just going to go to court. We're going to see what court does. We've got all the things. Law nerds, just grab food. I've got food. I've got coffee. Let me know what you're drinking because I am so hungry. Have we had breakfast yet? No. Do we have it with us? Yes. So once we get rolling into court, I'll probably mute myself and eat breakfast. But we've got a number of these hearings that we've got to get through. And I'm real curious to see what the court does with that dog behaviorist because the court was like, only a doctor. Only a doctor. Well, let's see what happens. And I have one question from the chat that we've got to get to before we even roll the intro. How do you find out what happens in federal court? Unlike Vegas, there are reporters that tell you what happens in federal court. So the media will be present in court, but there will be no video audio. So we are going to have to rely on those in court. But also federal court is going to ask a lot of questions. They're not going to rule. So we're going to have to wait for their ruling. So we still don't have rulings from the court. We have rulings on a few of her motions, but the defense filed a whole bunch more motions, including a motion to reconsider. The Commonwealth turned over more information. If we have a break, we will get into some of those, but we're going to hear about them, I am sure. I mean, this is pure speculation because we haven't watched the hearing yet, but I think we'll probably hear at least rumblings of them because the motion to continue, the motion to dismiss involves the things the Commonwealth has turned over. So instead of me telling you and then them telling you, we're going to let them tell you and then I'll fill in the difference at the end because I want to get to court, don't you? I want to roll the intro. Let's go to court. Law nerds, glad you're here. Let me know where you're coming in from, what you're drinking. Replay crew, love you. Yes, I do the old heart hands. I can't do the other one. My fingers are broken. There will be timestamps down below for everything. If you guys missed the Emily Show podcast this week, that's where I talked about the motion to dismiss. Emily, have you covered it yet? Yes. In the Emily Show podcast that drops on Monday, the best way to make sure you don't miss it is to have the Law Nerd app because it will keep you in the loop. Let's loop into court, shall we? Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the Law Nerds unite to talk about facts, not... Let's get into it.
All right, you guys, let us go directly to court. So we will get rolling. Some of you guys are saying that the audio is completely glitching. That's got to be on the YouTube end. That is not on our end. Our stream connection looks good. So I'm not going to roll to court just yet. I would refresh. Let me take a look at the YouTube end because it looks good on our end. But I would exit and come back because it seems that is on the YouTube end, not on our end. So YouTube does glitch on occasion. We're going to roll to court. So just go ahead and refresh and let's roll to court and make sure you guys can hear. Because we need the hear yees. Yes, the hear yees are faint. Oh, that was on me. The hear yees are faint, but hear ye, hear ye, hear ye.
Before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
And I will move the closed captioning in a bit. Those are on our original feed, and I don't want to double them up. All the attorneys are introducing themselves. All of the defense teams there. I'm going to try to gain this up just a little bit to make sure we've got, it just needs a little bit of a bump. So give me 1 second, but I will move the closed captions in just a few minutes because they were on the feed that we're pulling from. So I can't move them just yet, but that will change because it's our feed and we can do that.
We've got a few things to cover today. We had a couple of questions to finish off.
Okay, so the court is going to lay out for us what is getting covered today. So let's see what the court has to say. This should give us our kind of roadmap today. And this roadmap is going to work for us today, I hope.
About the defense position on the opposition to excluding the ARCCA witnesses. Then we'll go on to defendant's motion to exclude.
Did you hear what she just said? I still got stuff to talk about with the ARCCA witnesses. Y'all.
Excluding the ARCCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby.
That's the dog guy.
Crosby, and then we'll go on to the
I'm sure Dr.
defense
Crosby
motion
doesn't want to be called dog
to
guy, but
exclude
dog guy.
Robert Gilman. I know they're both under Daubert grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed
motions
to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the tapes at the Canton Police Station video. So that's the order that makes.
So that's the order today. She wants to talk more about the motion regarding ARCCA, then the two defense motion regarding Commonwealth witnesses, then into the motions that were filed. And for any of you having audio issues, refresh. It is on YouTube's end. There is nothing on my end that I can help you with. It is on YouTube's end.
Makes sense to me to finish up what we already had scheduled last week. If you don't hear anything else. So, the questions that I have. Before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the meetings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you act for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team.
Oh boy.
You all know that. Do you understand that, Mr. Yannetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Oh
Mr.
boy.
Alessi?
Yes, Your Honor.
So, each attorney is legally accountable for the actions and statements of the entire team. So, now the questions that I have, Mr. Alessi, that you said were welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you called. Could you stand, please? Because I didn't
Yes, I was going to go to the podium.
Sure, go ahead.
For those of you asking, doesn't that apply to the Commonwealth too? Yes, it absolutely does. She's not talking about the Commonwealth at the moment. She's talking to the defense because she has more questions about the ARCCA experts. The defense filed yesterday a motion amending their opposition, and they amended their opposition because in their opposition to the defense motion regarding ARCCA, they said they did not pay the ARCCA experts. And so the court is coming in hot today with the, remember, when the defense speaks for the defense, they speak for everybody. This is probably why she hasn't ruled yet, because she's still mad.
Thank you. I didn't want to stand while you were talking.
You could stand. All right, so the pause email, as you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Woolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. You will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email from Daniel Woolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it.
She is not happy.
Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARCCA and Mr. Jackson regarding compensation and
Oh, no, this is a problem. Okay. She's like, Alessi, you said you infer that the conversation stopped. But did they?
retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring, or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
Oh, boy.
I am inferring, Your Honor. I do not know that as a fact.
Okay. So now my next question is...
That's why he said I infer. He needs to have a duty of candor with the court. And part of why the court is so mad is regarding duty of candor to the court. It's not, we've gone beyond the discovery. Like, it's not about the pasta at this point. It's about what was said. And I think it's sidebar where Jackson said that they never paid ARCCA, among other things. It is clear ARCCA got paid. ARCCA did not get retained by the defense. ARCCA was not hired by the defense, but ARCCA was paid for by the defense after the first trial. So any representation made during the first trial, I think it's fair that the defense says we didn't pay ARCCA. We didn't assume that we paid ARCCA. Things that happened after July are the issue. I don't think ARCCA is going to get kept out of the trial because of this. This is about what the defense said and represented to the court and how they represented it to the court. Commonwealth's not asking for ARCCA to be out. The defense is not really saying that they think ARCCA is going to be out. We've shifted from whether ARCCA is in or out completely to what did the defense say to the court and when. And I know you guys do not like this judge. Most judges would be pretty pissed about this. It's not insignificant. It's the level of anger for the fuckery on both sides that we want to see, right? Also be mad. Also be mad. So the invoice and the emails and the representations to the courts together are the issue. And that is why the court is still asking about the issue. But yes, when it's like, where are these things from the Commonwealth? It's equally frustrating. And the court is much more upset about the representations to the court than about the discovery issues. So let's continue.
regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025.
To the defense.
Provided to
No, to the Commonwealth, from the defense.
The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time
Same time as what, Your Honor?
as the invoice?
Oh, boy.
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court.
That's a fair question.
Until I asked you midway through your proceedings.
It's a fair
In fact,
question.
I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. Seems pretty clear. This was filed, I believe, in the weekend, February 16th. In the Commonwealth's opposition, defendant's opposition to the Commonwealth's motion to exclude employees of ARCCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent.
Attorney Little filed something yesterday to clarify this point, but the defense wrote in their opposition in February that they did not pay for ARCCA. But they did pay ARCCA. And the defense filed a motion saying, by the way, we need to correct that. I think Elizabeth Little might not have known until the last hearing that payment was made. And that is an additional, from the court's perspective, misrepresentation to the court when in their opposition, they say, we did not pay for ARCCA. They did pay ARCCA. Paying ARCCA is not the problem. It's not about the pasta. Paying ARCCA is not the problem. Not being clear about paying ARCCA is a very big problem. And then Elizabeth Little said, our law clerk wrote that and I signed it. Well, everybody signed it, which is why the judge started out with everyone's responsible. Because Elizabeth Little's clarification was saying, I wrote this with a law clerk, nobody else. I don't think anybody knew until they went looking for it. And that's why she is so mad about the payment and asked a good question. When you turned over the invoice from ARCCA, why wasn't proof of payment turned over in discovery? Yeah, it should have been. And again, there have been discovery issues on both sides of this thing. I don't think she can smoke the defense on the discovery issue because goddamn, the Commonwealth's discovery issues have been massive. It's the candor to the court that's the issue. The discovery is not going to be the thing. But the court's not happy, and the court does not, I think, at this point, have a lot of faith in what the attorneys represent to her. And that's a problem.
Apparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
Yikes.
I'm going to answer it, Your Honor. I just wanted to make sure you were finished with your
Go ahead.
question. I learned that that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned.
You don't have to
I'm sorry.
repeat it. And again, what you know, and what all.
I don't know if anyone on the defense team, other than the person who said, yeah, pay it, knew. But it's not good. This is a problem. How does this impact the trial going forward? Maybe not a lot. But it's got to be resolved because the court is so pissed.
Counsel know is one and the same.
I understand, Your Honor. And I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through, and when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARCCA is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it, is in order to violate 3.3A1.
The reason he's pointing out the attorney rules and knowing is because he's saying, yes, we're all responsible for what everyone says to the court. But was this a knowing violation? No, it's not a knowing violation. We did not know. And we are being as candid as we can, but we did not know. This is the problem. Kat said in the chat, but Jackson knew. Jackson knew. I don't know. Jackson should have remembered, but yeah, Jackson knew. If Jackson didn't disclose that to everybody else, Scotty doesn't know, but that goes both ways. It actually goes much further with the prosecution team, but when it comes to a knowing issue, the knowing issue goes to Jackson. What did he know? And it's frustrating. And, you know, coming in hot to court for Alessi, it's like, good morning. You thought we were moving on to other motions. We're not. Back in the hot seat, just back in the hot seat, Alessi. First thing in the morning, you walk into court, barely a good morning. Good morning, everybody. What the fuck is happening? That's not a good day in court for poor Mr. Alessi. The hair looks good, but this is going to be tough. Oh, Alessi can absolutely handle the hot seat. It's early to come in this hot.
The attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works.
Correct.
I am responsible for everybody. But, Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. In something that critical of candor to the court, that's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does. about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with, Your Honor.
And no, I don't think Alessi's yelling. Alessi projects quite robustly. I don't think this is him yelling at the court. I think he disagrees, but he projects this way in almost everything we've heard him do in court at this point. But I love the way Alessi breaks things down. And it is always a respectful disagreement, but it is, Your Honor, yes, we are responsible for what everyone says. But if you're going to bing somebody on an ethical violation, then they have to know. It's a fair argument. And the court wanted clarification. I don't know if she's going to like this clarification, but Alessi's like, look, there's a lot of people working on this case and we didn't know. And is it going to keep the ARCCA witnesses out? Unlikely. Is it going to remove Jackson from the case? I think that would be incredibly extreme. And I think there would then be an interlocutory appeal and then the trial would get bounced. I don't think you can remove a lead counsel less than a month out from trial. I just don't think that you can. Can the court say, we have gotten to the bottom of this and I find that this was not candid? Sure. But I don't think she can bounce. I don't think she can bounce Jackson without it causing massive repercussions. And part of that would be pausing the case until the appellate courts dealt with it. And I don't think she wants to do that. So I think she wants to get to the bottom of what happened and what she was told and when and why she wasn't told about the payments. Because this is about the judge. This is not about discovery.
I'm not going to ask other counsel. All right, so let's move on to the next motion.
Your Honor, if I could,
we're moving on.
Tabs that I
That
have,
was
I marked
spicy.
as exhibits. I didn't do that last time.
The white book?
The white book, and I had marked, Mr. Brennan has agreed to them going. May I just offer them
Alessi,
in
I've
at
got to
this time? They're all marked. There were
modifying
two.
the
Your
volume
Honor,
for you, my guy. Thank
February
you.
6th was exhibit 1, so I picked off on 2 and worked it out before. What would you like me to do with these, Your Honor?
You can hand them to the court officer.
Alessi, the chat likes the haircut.
Well, there you are.
I mean, it came in hot this morning, but the chat likes the haircut.
What you,
Yes, but let's.
okay.
Oh,
Yes, 229.
All right, so let's go on to your.
Shanty, it's okay. It's perfectly okay to disagree with me. I'm just giving you guys I'm just telling you how I see it. I also, I would hate to tell you that something's going to be a way if it can't be that way or is not going to be that way. It's okay. It is okay to disagree with me. That is not a problem at all. Not all the chat likes the haircut. I get, fair enough. Withdrawn. Mr. Alessi, some of the chat likes the haircut.
All right, so let's go on. I don't know. 499. So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby. And I've
This
read
should
it,
be an
I've read
easy
it
motion.
2
I
weeks ago.
swear, Your Honor, if you do not rule from the bench on this, you know what?
Thank you, Your Honor. I'm just getting myself reoriented
Take your
back to
time.
it. Thank you.
I think this should be an easy motion. The motion with regard to Crosby is the motion with regard to the Commonwealth's dog guy. The court made really clear rulings previously. I think she just has to stick with those rulings. I really do. So, yeah, because when she ruled about this regarding ARCCA, and remember, ARCCA, I've seen a number of you ask, ARCCA are the accident reconstruction experts that were hired in the federal part of the investigation of this case, not in the state level of this case. Alessi, we stand. You're remarkable, my guy. I'm here for it.
May it please the court.
Will anything at this point, Mr. Alessi? Will anything? Will anything? But when those witnesses were testifying, and we have seen accident reconstruction biomechanical and biomedical engineers testify regarding causation of accidents and injury, mechanism of injury. the way a brain moves in a head when there's a helmet on. We saw a ton of this in the Gwyneth Paltrow ski crash case. And in Utah, the biomechanical engineers were allowed to testify, though I do not remember, to be fair, if any of them were also MDs. In this case, they were not allowed to testify as to cause of injury because they weren't doctors. And she said, in Massachusetts, you must be a doctor to testify about the medical cause of an injury, or the cause of an injury, because it is medical. And that's why Dr. Russell came in for the defense. Dr. Russell is like MD plus. And the Commonwealth brought in a dog guy that is not a doctor, and he wants to say that the injuries to John O'Keefe's arm are not from a dog or not consistent with a dog. Well, injuries to an arm, medical. Ergo doctor. So if what's good for the goose is good for the gander, I don't know where that phraseology came from. But to be consistent, the previous ruling was injury to body, doctor. This dude wants to say injury to body, not doctor. So will he be allowed to testify? I think this is a pretty easy one. Nope. I think this is a nope. I think this is an immediate nope. He can't testify because not a doctor. So we'll see what happens. I will be really feisty if it is not a consistent ruling on this one.
The entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render, and his methodology not only is not reliable, but it's not even documented.
Well, there it is.
Your Honor well knows the inquiry under Daubert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before.
From you, in fact.
Under the
So thank you.
qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony.
I don't care how annoyed this court gets with the way Alessi argues. He lines his arguments out much more like an appellate style or federal court style argument, and I love it. I really do. He is easy to follow. His arguments are linear. He's engaging. Emily, you've stand Alessi way too hard. Yes. And I'm not going to stop. His argumentation style is such an easy flow. So I'm going to let him get back to it. This is the beginning of Emily's super standing for today, because when the court is like, okay, Mr. Alessi, move on. Yes, he can be long-winded. I feel that too.
Is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage.
You can't see me. I'm going to save that question. It's a really good one. I just wanted to let you know that
Your Honor
I did in fact see it.
But that is clearly what he is trying to do. And I cite to NDAO
Fiddlestick Maker, thank you for that in the chat. I appreciate it.
NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe.
Need be
Similar
doctor.
statements. So it's very clear that's the subject matter of his testimony. Your Honor stated, with regard to Dr. Rentschler, that
Your
it
Honor
is clear
said
to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury, the key point. Only an MD can do that. That's what Your Honor said was the clear law in Massachusetts. Admittedly,
Oh, I turned him down on my end. Sorry.
Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian. He's not a forensic odontologist. And those are all disciplines that
Say
can
that 10
even
times
get
fast.
near the type of subject matter that he's looking to opine about.
Yeah, done.
He tries to dodge that very impactful standard that Your Honor established by saying, well, you
What's
know,
going on with these lights up here?
this case is not about the treatment of the decedent.
It
It's
doesn't
not a case
matter.
about the treatment of the wounds on the right arm. And yeah, you'd have to be a medical doctor to treat, but that's not what the issue is.
That's
So
not
I'm
the
okay.
standard. That's not the standard.
It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor.
Yep.
With regard to his area of expertise, it can't be more obvious
What even
than
is it,
his
Your
own
Honor?
proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine
A
behavior.
behavioral consultant.
And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualifications prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further
Agreed,
than
let's
the
be done.
qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense.
Did you catch the Celiaism? We need go no further. Whoop, there's your First Circuit Court of Appeals. We need go no further. The thing is, then you have to go no further, Alessi, which he does not do ever. But if we get to you need go no further, then you have to stop quickly thereafter.
That when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor, with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His
we're going further, though.
methodology is essentially, he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's
Purportedly
no
Chloe.
documentation of that, but let's assume hypothetically it is this dog Chloe.
How the fuck do we even know what dog it is? All of you have been asking me, how do we know what dog it is? I don't know. They purport to be the dog.
So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right
Look
arm.
at this photograph.
And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog. And this dog, so he says not only not Chloe, but no dog.
And he can't make that.
Then he goes even further.
He can't make that opinion.
And I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp
closed caption.
object.
Go me.
It just goes to show you how far
All right, now I can
he is
handle it over here.
afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human.
Right.
He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is
lacking.
Remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ABFO ruler in them. So he tries to use the wristband as a surrogate for his measurements.
And no one, during the autopsy, they could have put a ruler, and there are standard rulers by the thing. It's the biggest problem I have shopping online, particularly, is I cannot tell the size of anything. I mean, I also have like no visual mind's eye at all. So like Tetris doesn't work for me either, but I can't tell. Put a quarter next to it. How big is this? I don't know. So trying to use the hospital wristband to say, okay, well, the wristband's about this size, therefore up the arm, these injuries must be this size. They needed to be measured at the time. They weren't. There's not a lot you can do to undo that. So it's difficult when there's no scale.
Provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study, he doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor...
Oh, he's getting his notes. I will say, of all the things in this case that make me mad, of which there are many, the coroner not taking measurements of the injuries to the arm is probably towards the bottom of the list, because it seems to me when they brought in John O'Keefe, they were not investigating. It seems from my memory and also from what we've seen in the case that the coroner he was hit by a car, and that the coroner went to look and see if that was consistent. But I think there was quite a lot of input there on he was hit by a car. So I hope somebody asks if it is the coroner's regular practice to measure things, but when they are not cause of death, I don't know if that is their regular practice, but it makes it really difficult to investigate what happened there when they aren't measured. It's just, of all the things, there's so much more to be mad at, which is terrible, but it's a problem. Oh,
Commonwealth, in its
just
first
like
response,
my allergies,
states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm. What recognized methodology? Where is it? It's not in his report.
Your Honor,
And
I
it's
can't
not
find
even in
it.
the opposition.
Where?
So they
Methodology?
try to
What?
brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is...
Your Honor, it's based on facts. You have to have more beyond just facts. There needs to be the next step.
His report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion.
Incurably curious. I agree with you. There should be. Incurably curious in the chat said, my husband is a PhD who worked in the pathology department of a major university. He says that there should be a ruler in every picture and measurements in the written report. I don't disagree. Of all the things in this case that I am mad about, this is the one I am at the bottom of the list of things I am fluffed about, because there was so much else in this case that just wasn't investigated that I'm not shocked. But yes, there wasn't a thing. It would have been helpful if there was, for everyone involved. And at the end of the day, one of the things that makes me really frustrated about this case is that John O'Keefe and his family, though I know they frustrate many, his family deserves to know what happened to him. Truly deserves to know what happened to him. I think the community deserves to know. I think his department and friends deserve to know. People deserve to know what happened to the victim. And I don't think anyone tried to actually find out. And it pisses me off.
No support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was.
You did.
For them to come back and say, oh, no, the methodology, it's recognized.
They did not.
Here is the basis for it.
They did not.
It gets worse for the Commonwealth, Your Honor, on the methodology, because...
Unless he's like, I have too...
There
Your Honor, I have too many notes.
Potentially some methodologies that might be used, they're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission, the Commonwealth put in, very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that, and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our
Don't make me
opposition.
call in Dr. B.
And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound, and there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with...
Anybody else looking at Alessi thinking he was just going to go... I was just waiting. I was waiting. I'm teasing. We will have another day where we talk about forensic odontology with Dr. B and the issue of dental models. Because one of the things about dentition, and I don't know how true this is for canines vis-a-vis humans, but the jaw joint is dynamic. So you also have to account for the fact that the jaw joint can be a bit dynamic. Again, I don't know how true that is, dog versus human jaw, but there's a lot there. But I was waiting for Alessi to just hiss at the court at this point. I was just waiting. Didn't happen. When he was starting to say he, I was just like, do it. Do it.
Two parts is a questionable methodology. He doesn't employ the overlay method, the part two.
Dr. B's working out at the moment.
The molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More important, WHO makes it clear that the only people that can do that are forensic odontologists. People that can do that are forensic odontologists.
That was not me.
And even then, the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the womb. 0.
I said I was going to ask. I
So
said I was
what
going
are
to
the
eat while he
other
was chatting,
errors
so I'm going to
of
shut up and eat a
Dr.
little bit of
Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated...
Dr. Russell ate this up. You know, Dr. Russell was sitting there being like, they're saying I'm not an expert, and every expletive I add in is probably not what Dr. Russell thought, because she genuinely seems like she would never, but maybe she would. We don't know. But after the length of Daubert hearing they had with Dr. Russell, who is, well, an MD amongst all of the other things, to give her a report from a behavioral specialist, and I am not knocking behavioral specialty in dog training. I am sure it is difficult and there is much needed, but for her to get chomped at about her expertise, to then have the Commonwealth, who chomped at her about her expertise, submit a report from someone who is a behavior specialist to challenge her expertise, she must have been sitting there going, are you fucking joking me? That you said I had no methodology and you are bringing in someone who trains and works with canine behavior to challenge my medical determination? Are you fucking joking me? And so her written out ruling was like, well, let me tell you, I covered that if you want to go see it. She's just so done. So done. This is true, Paige. She probably does swear a lot. But the fuckery. She also worked in the coroner's office and in the jail and at Corcoran. She would have to have a sense of humor. So that.
The arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that?
I'm actually
Your
going
Honor
to eat, or I
may
will
recall
be
Dr.
cranky.
Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in a defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine, but the fact is, her main point is he never accounted for that in his methodology. It's not an opinion, it's a methodology. So
Humans move
again,
and are
if
squishy.
he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support. But he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained, they have to give a fair and accurate depiction, and you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion.
Unless he's like,
and
I
just
counted
the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. She had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin. Human skin, when there's any pressure, particularly with a bite, it moves, it dimples, it hits the muscles, etc., etc. He gave no account for the condition of the human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So, with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his thesis.
Of course you did. Of course you did.
What I found is,
it's like, Your Honor, it was fascinating.
Probative of the issues I just raised. So I looked at his and read 179 pages of his 2016 Master of Science thesis that they cited. In it, he talks about, on page 46,
give us the tea, Alessi. Give us the tea.
Defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute...
I recall that we spent 2 days arguing about pattern recognition with like 3 or 4 different filings about pattern recognition. For them to bring in an expert whose entire thesis is based on pattern recognition is the nerdiest, most wild serve I have ever seen. It's just like, remember the Commonwealth saying pattern recognition? WTF with pattern recognition? Really? Oh, Alessi's like, I read 179 pages and I was going, of one of the Blake Lively filings? No. Of this dude's master's thesis. He's like, no, I'll find it. Ha!
Probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them.
Bro relied on them.
And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern of dog bite injury as a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is now one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how
He's going to get to GTFO in a
difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, very, and I couldn't agree with Dr. Crosby more on that. He's
like, look at how right he is. He just can't testify about it.
About the fact that there's
My level
no
of petty.
accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says.
I'm never going to hear
Although the
ABFO
does not
correctly.
specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that you just, even with this methodology, you've got to have it supported by this hard evidence that he doesn't have.
I have to be fair here and say, when Alessi had gotten to, we need not go further, he really didn't need to go further. So for argumentation, do we need to be here? No. No, we don't. Have we gotten into a bit of overkill? Yes, we have. Here's why I'm not mad at it. One, I like Alessi. I like the way he argues. I think he's very smart, and I am amused. Emily, is that completely fair? No, because if it was Lally sitting up here reading me somebody's master's thesis, I would be bored and screaming at the screen. Is that me? Yeah, that's completely on me. Could he be done by now? Yes, he could. Am I mad about it? No, I'm not. They attacked his expert, and he's going to use the masters of this expert to turn it around. Also, Alessi was sitting there 2 weeks ago ready to argue this motion when the court cut the day short. He'd already come up, down, whichever way from New York. Don't ask me about geography, but he had already traveled from New York to Boston and was like, can we just hear my motions? And the court's like, no. And so he's had an extra 2 weeks to pull stuff up, and he's not under the time constraints you would be in federal court. I know that there are feelings about this judge. To be fair, in every hearing we have seen, though the court will interrupt and ask questions and interrupt and say you don't need to repeat yourself or whatever, every time we've seen the defense want to take time to make an argument, I have not seen them be cut off. They have been allowed to make a full record. There are like 5 motions pending today. A lot of judges would have been like, I understand, Alessi, because the point's been well made. She has opened up space to allow them to continue to argue. And I think it's fair to allow them the space. So he's gone a bit far afield from where we need to be, but I'm kind of living for the shade. Could he have stopped? Yes. Is he long-winded? Yes. Does he sometimes repeat himself? Yes. Do I recognize my own tendencies in that very much? Yeah. Yeah, it's also me. It's also me.
Anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology.
Whoop.
He never worked with a forensic odontologist. In the case law that we point out,
don't give them
even
ideas.
in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology.
Not
so
one.
Then I said, well, maybe in his PhD thesis, which is more recent, 2023, maybe in that thesis.
2023? Bro just got his PhD. I mean, congratulations on your PhD. It doesn't necessarily mean that this is the right case for you, but congrats on your PhD. There have been times in my life where I've hallucinated and been like, you know what? Being a lawyer with a JD and calling yourself a doctor, in my opinion, is incredibly douchey. My opinion. But there have been times I'm like, I would love to contemplate a PhD. And then I'm like, Emily, just write a book. If you want to write a PhD, just write a book.
That the
I can't wait for
Commonwealth
this.
did not cite. So I went and read 143 pages of that. And
Me reading
there
all of
is
the lively Baldonia.
zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities, a Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods in reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior. Second sentence,
Right, it's
page
not
63.
about this.
Classifying dog bites. This
probably
provided the
knows a lot about
opportunity to
behavior.
develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's a
I love that the PhD is about the dog's perspective in a dog attack. I imagine it starts with, yeah, but fuck you, and then goes from there. But I'm interested nerdily. Does that make this person the right expert for this case? No.
thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it
because
or
he's
that
not that
he
person.
is even qualified to
Right.
do it. So in sum, Your Honor, with regard to Dr.
You promise?
Crosby,
You said in sum.
whose degree is in veterinary science. I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might think that's
did.
what it issued. He's not.
I did immediately the first time.
He was a police officer for 22 years. And even then, he didn't deal, he wasn't like a canine
What?
police officer. He had an interest in them then. And it wasn't until
He was an officer for 22 years, interested in the doggos, and never worked as a canine officer? What? Wait. What? Okay.
he retired that he became active in dog behavior and how dogs behave, if they're aggressive, etc., etc.
Okay.
So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications to do that. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert
The Commonwealth was like methodology.
That alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell,
Let's not waste everybody's time with the hearing.
it was a close call for Dr. Russell in her ability
Who's a
to
doctor.
testify. If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby. So I respectfully request that he be excluded. There's no need for a Daubert hearing.
Nope.
It's plain on the papers.
I agree.
And it's not something that is curable.
The hearing's just a waste of time.
The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the decedent.
All right, thank you very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object, is he? Are you planning on bringing that in?
I wouldn't ask him to do that, no.
Okay. All right, so I'm hearing one motion.
Yeah?
Yes.
I'm interested to hear what the Commonwealth has to say. And then I'm getting back to eating my breakfast.
Mr. Releasy tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr.
About
Russell
the
never
cause of
had
them?
before this case.
Or medically
And so,
identifying them.
In preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his
What
analysis,
methodology?
his examination of Chloe, and his testing. And that was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided,
Also, I can see testimony regarding dog attacks in civil cases and other cases, but this is not a known attack. This is, did these injuries come from there?
provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Releasy's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications
His package,
that he
his
relied upon in this case.
Proposals.
There are a number of publications, I won't read them all to the court, but we can see that he
I'm
relied
gonna
on
fix a feed real quick.
books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive: variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Lisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs.
I'm going to back up real quick. He keeps saying Mr. Alessi's trying to bind the court. That was the court's rule. It's not Alessi's rule. It's the court's rule. The court's rule was, if you're talking about the cause of an injury, you must be a doctor. And it was my understanding that the court's rule came from case law in Massachusetts, not just because the court felt like it, because generally courts, well, don't just go with because I said so. Sometimes, yes, but there's normally law backing it up. And this judge really does seem to go with, well, this is the law and I'm going with that. And she ruled on it very clearly. So it's not just him. But all right.
And his education.
I'm interested to hear this argument.
It seems as though Attorney Lisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor.
In this field?
There is no cases that they provide that bind that limitation. The qualifications of...
They cited to the judge. Footnote, judge.
Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
I didn't think you could do that.
The different autopsies he has, and I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the packet? The exhibits that I have are attached to the Commonwealth's, the defendant's motion.
They have.
I don't know that I have all the reports.
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have.
Oh, Your Honor, this is a great question. Let's back that up again. This is a great question. Have you proven that it's the same dog?
Not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the
Defendant
mold
disagrees.
analysis report.
Defendant disagrees strongly. Did you? Look, I don't normally pay attention to or point out the defendant's facial faces or responses in court during trial. I really try to focus on the attorneys. However, we know that Karen Reed is deeply involved in her case. I imagine she knows every single piece of paper that's come across everything in this case. And her lawyers are sitting there doing nothing. And she's like, Oh, this is a very interesting interaction. Emily, are you going to run that back one more time? Sure am. Sure am.
The verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the
Did you see
mold
Alessi?
analysis.
Alessi was like, Alessi's frantically remarkabling. Karen Reed's like, no way. Alessi, has he provided it? Now we need to know.
Report of Dr. Crosby, which is not.
I think that's attached here. I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth, and then I asked him to supplement a report regarding the mold.
And that's been provided to the defense?
It has, but it has not been provided in this package, so I can provide that to the court. So I'll supplement those.
I have questions.
Two different items for
I
the
have
court's
questions.
reference. In addition to his experience, he was Chief of Animal Care and Protective Services of the City of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published.
It seems like he's the person you would want to determine if there was a dog bite or a dog attack at an apartment complex, whether or not the dog legally was required to be put down or what have you. That seems like an appropriate area. But based on what the court has said here, I don't know if this is an appropriate area. I have so many questions.
Has shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate canine brain project, 2023 to current. It's associated with Harvard University. Duties include the investigation and documentation of dog bites and related human fatalities.
I've been told it's Harvard.
Also, Division Management Consultant for Animal Care and Protective Services, City of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities.
And I bet those are civil
Now,
mostly.
In Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. So when we compare...
Y'all, I am going to just be real transparent with you right now. I am having a very hard time keeping an open mind with this argument because of how much he attacked Dr. Russell. So it's really hard for me to reconcile the two in my mind. So I am sitting here like, just seriously right now, I'm trying to take a step back. I just wanted to let you know where I'm struggling because I'm sure that you guys are struggling too. I am trying to take a step back and hear his arguments about why this would be proper. And I'm not hearing arguments about why this would be proper. What I'm hearing is there are other cases that might be appropriate cases for this individual to testify in. I imagine a lot of them are civil because if you have a dog-related fatality, that's very rarely going to be a criminal case. It might be, but it's mostly going to be a civil case. That he can say these injuries came for a dog from a dog when it seems that his experience to make those determinations comes working in lockstep with the pathologist, the coroner, etc. So it's very hard for me to find the arguments well taken for me. And I'm trying to keep an open mind, but I'm also just like, what? So that's where I'm at.
I'll refrain from getting into too much of a comparison. When we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not
Alessi has infected all of us. It's now Dr. Crosby. That is it. Also, depending on where you live in the U.S. today, I know you guys, if I'm already seeing weather, I know a lot of you are. So if any of you feel like you need to bounce to go watch what Ryan Hall-y'all's saying when he goes live, please don't feel bad. This will be on replay and is definitely not as urgent. But yes, don't feel bad. We're always here. Dr. Crosby.
Supported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that he has measured the distance of all of those teeth specifically.
Okay.
Then in his methodology, he outlines each group of lesions, specifically lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look,
dynamic.
as Mr. Lisi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case, he finds
we got
canine
questions
DNA.
about all of that.
He does look to alternative sources, and mindful, there was pig DNA found, so it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence that there is no animal DNA.
Well, there is animal DNA because pigs are
While
animals, but
there are different methods, and some of the things that Attorney Lisi spoke about, dentition, deal with human biting, not dog biting. His methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case. He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based, not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered.
In the one report?
And he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand.
that's not the standard. But he is saying this is a rebuttal witness and we have the right to a rebuttal witness. I don't know if he can give all of the opinions. I think there might be a world where he could talk about dog attacks, but that is, there's going to be limits on relevance there.
And provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?
Absolutely not.
Okay. All right, Mr. Alessi, any follow-up?
Thank you, Your Honor. Thank you.
Mr. Alessi, can you please clarify? We want to know how you were alerted that it's the same dog. Please. Yes, rebuttal still has to be qualified to testify, still has to be able to give sound
Commonwealth
reasoning.
did not address in its presentation, you heard one probative, legal, or factual point I made because they can't specifically. The Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what? It's important. You can be qualified to testify, and if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it, but the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. It wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number 2. Mr. Brennan mentioned he cited numerous journals. Your Honor,
Is Leslie going to grab a
ask
stack of journals?
the court to take a look at his report. There is now...
Hold on, so that's exhibit 1. if we're
Yes,
doing-
exactly.
Just give me a minute. Just put them back again.
I think it's fair when Brennan
So what
said
page?
Every
he
page.
testified as an
The
expert to
point is,
qualify.
there's not one footnote
What kind of expert?
in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted, and nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Daubert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Daubert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
I appreciate that he's giving the court time to get there. Alessi knows this report well. I can see why they brought him in to
he's
handle
got
it
it
the
in alphabetical
experts.
order. Importantly, the page before, 1399, at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case.
He brought that up in his...
You can't have an expert report
He brought that up in his
does a data
motion
dump
as well.
of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did.
See all.
And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So
Fertile
when
imagination,
Mr.
sir?
Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't, because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no
He couldn't have.
statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is, because he's participated in autopsies, he must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that book is not peer reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Daubert, you gotta have experience in the subject matter. I don't know what he means by field. Is
You
it
do.
dogs, dog behavior?
Dog behavior.
In Daubert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated.
We got to
He mentions Harvard, which
Our pens
people
are matching.
use for obvious reasons. You know, it's Harvard. But what is it that he is participating?
I have been told it's Harvard. And again, Harvard, I will say, when we played Harvard, when I was at UMass, they were not always kind about the reputation of our institution. And we were not kind in the brutal smackdown that their team was delivered, because what they were not great at is water polo. But it is Harvard. That is the only way. But also, yes, it's Massachusetts. They're going to, you know, bring in the storied institution. Your Honor, it's Harvard.
In Harvard. And this was from the words of Mr. Brennan, canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry.
We like the
You've
facts.
got to base your opinion on a reliable
scientific
methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology. So I am still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology?
It got rehomed. Wait.
Where's the home in the scientific literature?
That's on me. That was me. I got way too excited about being snarky, and now we have delved into Healing Forest ambiance. I apologize. The internet has decided we all need to take a breath. Apparently, we all need to take a breath. No, just me. The internet has decided for me, so I'm going to have to back up in time to where we were to let Alessi finish. But it was funny that he, I think, was teetering the line of rehomed methodology, and I was living for it. But let me, I will link the healing forest after this once we get back to Alessi. Don't worry. Hold on. Let me copy the link so Miguelina can put it in the show notes, but we'll put it in there in case any of you need some ambiance in the background. All right, let's continue. Emily, what's up in your YouTube playlist? Ambiance is generally what I have on the screen when I'm working. It will normally be some kind of ambiance, some kind of somebody talking, and then something else. But I was just trying to make a joke, and then I yeeted myself. So let's see if we've gotten back to where we need to be.
That opinion to any methodology. And as a matter of fact, Your Honor,
Yes.
and that's the entire basis for what the Commonwealth is proffering is support that, 1, he's qualified, and 2, that his methodology is reliable. But he doesn't even state what his methodology is that he used
It's been
to come to that
rehomed.
opinion. I've never seen a proffered expert
I put on lo-fi girl quite a
not
lot.
even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence.
Oh, I don't think I went back.
They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And, Your Honor, there is a deep and typical of science, complex way to determine hardness of ground.
He just
And
put deep
he
and hardness
doesn't
in one
even
sentence.
begin to discuss that whole science. And Your Honor may recall in previous Daubert-Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most...
Where are we? Did I not back up enough? I might not have backed up enough. Hold on. Because we should be there should be an argument regarding a meteorologist at some point, but I thought we were still dealing with, no, we did that. No, maybe not. All right. I didn't back up far enough, chat. That's my apologies. Hold on.
Those cases, Dr. Crosby testified on...
The thing is, when the arguments are interchangeable, it's a problem. All right. We need to get to Alessi talking about rehoming the opinions again.
Report. Does he say this methodology,
Apologies.
this measurement methodology, is accepted at all? And you have
Next
to
argument's gonna be
either
more of the
show in Daubert-Lanigan that
Sorry.
either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Daubert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what
There we
Mr.
are.
Brennan
All
has
right.
to be referring to. If Your
Better.
Honor would please turn
Better.
to the end of the report. This starts on NDAO 1400, very much toward the back.
We were right in this vicinity when I completely...
So he's
Fucked
got
up
it
my
in
screen.
alphabetical order. Importantly, the page before, 1399, at the bottom is entitled References and Materials Consulted That May Affect
All right.
My Opinions in this
I'm going to
case.
zoom past this just a little
You
bit.
can't...
Yeah, it's a data dump. That's where we were on the methodology. Let's see.
etc. So I think the inference the Commonwealth wants Your Honor to take is, because he's participated in autopsies, he must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done.
So yes, if this sounds familiar,
He
it's because
mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that book is not peer reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field.
but he
What
doesn't
field?
say which field, right? All right. I want to make sure we get to where we lost ourselves.
Mr. Brennan made is particularly telling. He said
Facts.
Dr.
There we
Crosby
go.
bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on
I'm gonna leave it here so it can
reliable
dovetail.
methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology.
We went a long way for
So
that joke
I am
this morning.
still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home.
It's
because
been
it's not
rehomed.
generally accepted. So he is not
Go to your
qualified
home.
under Daubert, Lanigan, and his methodology is
That's
an
it.
orphan.
It has no
and
home.
For those reasons, not only can he not testify with regard to whether the cause is a sharp object,
Rehomed with all the phones.
but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Okay. Anything else, Mr. Brennan?
Briefly.
Oh, good. All right, Brennan. Do you have a methodology for us?
On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinion. I will give you specific cases where he's been qualified in state and federal court.
In what area?
Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the
You can't, you're telling me that you're going to say this idea of pattern recognition when it's in your expert's thesis as well.
details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Alisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report, but what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's affidavit in support, there's something, to be intellectually honest about it, striking. Kind of like her original report where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter if somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before.
In what area? Again, Brennan's entire arguments have been attack the other expert. His entire argument has been attack the other expert. It's nothing about his expert. Where did he say, Your Honor, he's qualified in state court as an expert to recognize the cause of injury as from or not from a dog, and the methodology he uses is clearly set forth. Instead, it's, Your Honor, our expert's an expert, but their expert, he continues to try to shift the focus from this is why our expert's qualified to this is what's up with their expert, and at least ours wrote his own report. Attacking the other side doesn't answer the question, Brennan.
So before we move on to the next
Good
motion, the
God.
next motion was, it was
And that's the end of this motion. That was something. I'm not going code red yet, y'all, because I'm leaving open the possibility that other fuckery unfolds, but it's not well taken.
filed after the other motions that we finished here. It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative of Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Leslie, this is you again, right?
It is, Your Honor.
All right, so I'll hear you. And this is paper 515, Jim.
I'm just taking a note real quick.
May it please the court,
They are moving on to the defense's next expert. No, the defense's next motion regarding the Commonwealth expert. This is a Commonwealth expert whose opinion seems to be regarding how hard the ground was. So a meteorologist of sorts. The defense filed a motion to exclude some of the opinions, or have a hearing to more thoroughly explore those opinions. So that's what this motion is. The defense is moving on to the Commonwealth's next expert. The Commonwealth didn't file a written opposition and is going to just argue it orally in court. That's not uncommon in criminal law. In this case, it hasn't happened a ton, but it's not uncommon that things just get argued without a written filing. So the defense is trying to narrow down what this next expert can testify to. Ooh.
Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34.
Just go on. How many times are we going to say hard? Are we going to full-throatedly argue about the hardness? Just put it in the chat.
Fairview on January 29th, early morning 2022. He states in what is a certified weather statement. That's quote, certified weather statement.
Certified. Wait a second. No, Emily, no.
And we don't challenge his statements about what the temperature was and precipitation.
Your Honor, it was in fact snowing. We don't challenge that it was cold and snowing. Ippy Fluffy, I have to answer this before we move on or my brain won't close the loop. But my kid and I, my teen and I have a very similar taste in music, sent me a meme, probably on Instagram, that said it's raining men and let the bodies hit the floor is the same event from different perspectives. And I'm still not okay. I'm still giggling. But also, he's not saying the meteorologist can't say it was snowing and that it was cold and that there were wind shears or whatever. But can he testify to the hardness of the ground? We'll see. All of you are like, I need that meme. I'll try to find it and put it on my Instagram stories. Whoever came up with the meme is not wrong. I just had never thought about it. I was like, I mean, maybe.
But what we do challenge is his opinion with regard to the hardness of the ground. With regard to his
How hard was it?
qualifications, he is not, his qualifications to opine on the hardness of the ground.
You need somebody to
He
be an expert in
is
soil?
not a geologist.
Right.
He's not a pedologist, i.e. a soil scientist.
I actually have a
There's
friend who's a
specific
geologist.
field for that. He's not a hydrogeologist, which is a scientific discipline that
Can you go through all of the different geology disciplines? Because now I'm fascinated.
blends water movement in the subsurface, particularly the soil.
He's like, yes, I
He's
can.
not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have
I imagine, and I am not a geologist, I am not an expert in many, many things. But I would imagine there are very specific fields that test ground for shit. Like in California, you had to do a whole bunch of ground testing with building because, you know, the ground moves and some of the ground, depending on where you are, is more sand than not. And I imagine in other environmental impact studies, you have to know what ground you are dealing with before you can build things. I imagine that's like an entire area of study on the ground, how the ground moves, how hard the ground is, how hard the ground might be if it freezes, doesn't freeze. Like, I don't know if that's a meteorologist though. I mean, we need meteorologist D. Cortez in the chat, who's a law nerd and is here often. But I think that the meteorologists do the above ground stuff. All of you are like geotechnical engineering. God, law nerds, you're the best. Look, chat is Bay, civil engineers, land surveyors, geotechnological report. See, right? There's got to be someone who knows. And y'all are like, yes, actually, there's lots of someones who know.
Have any
Thanks,
of
Chad.
those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling
I will find the meme.
statement that he makes is he puts his opinion in quotes.
Oh, that's where we were earlier.
So his certified weather statement
Damn,
is
certified lover boy. I'm not going to be able
hard
to
as a
stop.
rock, I believe. I'm looking for it.
So I'm sorry, would I have?
Isn't that a car commercial? No. He's like, his expert opinion is in quotes and it says it's hard as a rock. Just rock hard ground there.
Is hard as a rock, I believe. I'm looking for it.
So I'm sorry, would I have? There are a couple of exhibits attached.
Thank you.
to that
Chevy's like a
exhibit,
rock.
Mr. Leslie?
Yes.
So one's exhibit 1, I don't see any.
I'm sorry, Your Honor. It's Exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it.
Read me the
I
quote.
don't see anything that says certified weather statement. It's an email, right?
no, his report is Exhibit, well, it does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So, Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is.
Here's my question. I don't know. I think the Commonwealth is trying to show that the ground is sufficiently hard to cause the injuries on the victim. They didn't do that the first trial, so this is a new expert. But I imagine this is not the right field for soil hardness.
It is. He didn't say how he came to that conclusion. So
Also, did he go do soil samples from the front yard to tell you what the makeup of the soil is? Like, don't you have to do like core samples and shit? I'm just asking. It feels like there would be more than like, seems like it would be hard because it's cold.
it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And, Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss
not even
that
just the tip,
whole
Your Honor.
Science. And Your Honor may recall,
it's not the expert's fault. He's a meteorologist.
Hearings.
It's just not his area.
I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about?
Your Honor, meteorologists talk about the weather. They don't. They work song lyrics into their reports. They are on YouTube, which is where I watch my favorite internet meteorologist. I love that Alessi's like, we watch them on TV. We do.
They talk about the weather, the forecast of the weather.
Chuck Charles.
What is the weather? We all know what it is.
Penguins of Madagascar.
I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it, because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Daubert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about
Mr. Alessi, can you start singing She Blinded Me with Science, please? It would make my whole day. No? Bummer. Brennan,
Mr. Brennan,
maybe
first
you.
question, do you intend to call this witness in your case in chief or for rebuttal?
I do, case in chief.
All right, I'll hear you.
Thank you.
Interesting. Hey, Mr. Brennan, I'm just saying, if you call this witness in your case in chief to establish that it was snowing and then you don't ask 75 witnesses, we will be grateful. Will it make up for the attack on Dr. Russell? Maybe not, but we would be grateful if you could just establish with the meteorologist that it was cold, that it was snowing, and what the rest of the weather was. That would be great. I'm very curious about what the methodology is for the meteorologist to determine the hardness of ground. Again, I wasn't aware that that's something that they did. I am a weather nerd in that I enjoy knowing about the weather, but yeah, it's normally the swirly weather that concerns me where I live now. It was the fire weather before, but.
The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed.
I think that's
Talk
fair.
about the temperatures, the wind conditions,
Fair.
also the snowfall.
Fair.
It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock.
Yes.
I think that concern is easily remedied.
By
I do
not
not
asking
need to
for it.
ask this expert if the ground at Fairview was hard as a rock. I can ask him about the document.
Do you see what's happening? And that's true. The defense narrowly tailored their objection to giving the opinion about the ground. There are times that I think this defense team overreaches. There are times when the prosecution team overreaches. This is not one of those times. The defense narrowed it down to talk about the weather. You're a weather person, but you can't talk about the soil. And Brennan is like, I can fix it by asking it better. So Brennan's not like, but Your Honor, there's methodology, because you know there's not, my guy. You know there's not.
And that the ground at Fairview was hard as a rock. I think that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time,
Does he know
the
that?
frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was hard as a rock, and state police who excavated can testify to that very thing. So Mr. Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Well, it's beyond
Say that, Mr. Lawson?
his expertise. And I think it's fair that state police that excavated, that were digging in the ground, can talk about the ease or difficulty of digging in the ground. I just don't know what was excavated because I don't think we've heard about it. And I don't know when stuff was excavated. But I think they can say if they were trying to dig around in the ground, they can say it was incredibly difficult. I think that's fair. But I don't know if this witness can talk about the ground freezing, or I think they can talk about freezing on the surfaces of like the road and whatever. But how many snowfalls do you need for ground to freeze? What's the water content of the ground? Like, there's a million questions here. So I'm interested to see what Alessi has to say, but it seems the defense has maybe, or the Commonwealth has backed up a little bit to, okay, we won't elicit that opinion, which is fair. I don't know what got excavated.
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned. but its proposal to have a meteorologist talk about how ground freezes
Isn't sufficient.
is still very much problematic, because, just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that.
And I see a lot of questions in the chat, so I'm going to answer it real quick because they're good questions. There are differences between a lay opinion testimony or observation and an expert opinion. An expert's not a percipient witness. They're brought in to explain something technical after the fact, where people that are there, that are trying to work with the crime scene, that are there that day, can talk about their observations without giving an expert opinion. However, you also have a jury that lives in this area. They're allowed to rely on their common sense that the ground might be harder during a blizzard than it would when the grass is freshly watered in the summer or whatever. So you might not need an expert for that. It's just making sure from the defense's perspective that that expert is told that they are not testifying about the hardness of the ground and that the Commonwealth can't elicit that testimony in front of the jury. So you can have observations different than expert opinion, and this is seemingly not the appropriate purview for this witness for expert testimony, because they are not an expert regarding the relative hardness of ground.
Benjamin J.G., 2005, freeze-thaw effects on penetrometer resistance and shear strength of...
Who the fuck named it a penetrometer? These dudes out here just wildin'. Penetrometer. They're like, what do? You penetrate the ground with it. It is now called the penetrometer. We have learned something new every day. Yes, we've gotten to the penetrometer. Things I didn't know yesterday.
How one has to do that. Benjamin J.G., 2005, freeze-thaw effects on penetrometer resistance and shear strength of...
Why don't you put those in right now? Was that just a Google search? I saw that you had it on your...
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald...
Oh, shit. Counsel, is that a Google search? No, it's not a fucking Google search. I'm not. This is a lessee. I'm not. This is not a Google search, Your Honor. I've actually consulted with sciencey people because I am a nerd who won't let it go. Let me wave my binder at thee. Oh, God. Oh, God. Oh, God. I'm gonna back this up just a little bit because I want to get. He's gotten to like the entire family line of the dragon at this point, and so I'm gonna let him cook without interruption. But is this a Google search? Is
2005 freeze-thaw effects on penetrometer resistance and shear strength of...
Why don't you put those in right now? Was that just a Google search? I saw that you had it on your...
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all.
No.
Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
Nah.
I'd be pleased to provide a copy to the Commonwealth.
All right, so
Nah.
I'll take this under advisement.
Was that a Google search? I saw that you had it on your thing. No, Your Honor. I consulted with an expert and said, How does one determine how ground freezes? And said scientist went, great question, happy to tell you. So the court has asked for more documentation. This is under advisement. Is that a Google search? What the fuck?
So how long do each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, the cases and the qualifications of Dr. Crosby?
I can have that to you today.
Great, okay. And those articles, Mr. Alessi, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
You let me hand it to the court officer?
That would be great.
He's like, I can enter a list right now.
As well. Is that your only copy,
And then
Mr. List?
email
Did
it to you.
co-counsel have copies?
Oh, no, co-counsel doesn't have any of this, Your Honor. I just need to black out.
He's like, no, they said, do your thing, Alessi. Do your thing.
Something here that's...
Sure. You don't have to do it right now. Do it before you leave today.
I'll do it before I leave, Your Honor.
That way
Thank you.
there, we'll see to it. Jim, can you get a copy made for everybody?
Oh my God. Today is going to just...
All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions.
Yep. Today's going to do me in.
This involves a transcript of it.
Commonwealth's motion for sanctions. If you didn't watch my coverage of this originally, just buckle up. We're just going to let it roll.
Read. I've listened to the actual recording. Maybe it makes sense to take a 15, 20-minute recess. Now, does that make sense to everyone? Okay.
All right.
All right, to the court, please.
Is the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just a transcript? Actually, I'm going to see counsel.
Oh, actually, no recess going to sidebar. I'm going to zoom. I'm going to zoom while they're at sidebar because they are going to sidebar. I'm going to just pull that up real quick. We are getting into the Commonwealth's motion for sanctions, whether or not the defense violated a protective order by some of the things they put in their motion. I'm interested to hear the arguments on it. There is audio that's been impounded. A lot of this has been impounded. It wouldn't surprise me if the court at some point, because I have a feed running, so court has gone back and forth to the fan. I wouldn't be surprised if the court held argument, or at least some of the argument on this, in closed court, because there is impounded items. We've seen them do that in court in Idaho, where they have held the proceedings impounded, well, not impounded, but sealed, where they kick the entire audience out and then hear it. Let's see what they say when they come back to court, and then hear it outside of the presence of everyone because it's dealing with sealed information. So that wouldn't surprise me.
All right, to the court, please.
I actually have a friend who's a geologist. You know what my text is going to be after this? What can you tell me about how ground freezes? Because I've never had a case where that came up. I've had cases where some weird shit's come up, but never the freezing of ground. But I also practiced in California, so not really relevant. But did it snow in Pasadena? Yeah, I wanted to get a whole PhD in whether or not it ever snowed in Pasadena, but that had nothing to do with a case that I was working on. Some of you will get the reference. Some of you, if you don't, it's Housewives. All right. Back to the OnlyFans. So I guess they weren't back in court. Let us continue to. This is why we leave Zoom room, because court's unpredictable. If we end up not catching up to live or catching up to live court and it's on break, I'll go over the newly filed motions. And Miguelina, depending on where we get with that, we'll send out a new app notification then. Let's get, I think we're back on the record for a moment. So let's get back on the record, shall we?
Brennan,
And then when the court takes lunch, I'll try to zoom through those, but I'll also take a quick break to get myself some more food.
on this motion.
Thank you.
There was a what if any joke within the motions, I think, or at least a wink that I thought was like a Bravo editor wink. It was funny. Are you chewing gum?
As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders.
All right. Commonwealth's motion for sanctions against the defense.
Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public.
We're going to end up down a whole rabbit hole on sanctions. So once we go here, it's not going to get undone. And I am surprised we haven't seen defense. Well, the defense is living in the world of motions to dismiss, but I'm sure there will be more. I'll let the Commonwealth argue and we'll see where we get.
Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order.
Which you can't
Now,
do.
it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, and given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information.
Well, it can be impounded.
In the memorandum, page 9, what they suggest to the court
This is the defense memo he's
is
talking about.
because the trooper did not want to watch the closing, it implied that he had been following the entire trial.
It's Proctor.
There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, there is no good faith basis whatsoever that that witness watch other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information to the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses.
Sir, I do not disagree with all of his arguments, and I know that might frustrate some. However, I don't think we have seen, or at least I have not seen, and I have a pretty decent memory. I have not seen the defense attack the court. He threw that in there, but I have not seen the defense attack the court. The text he is talking about is a text between Trooper Proctor and Lally that was under protective order, and the actual text, words of the text, were put into the defense motion. And if that's under protective order, then it can't be in the defense motion without being redacted out. I agree with him. I have not seen the defense attack the court. And I think he's tying that in to be like, and they're attacking you, Your Honor, and they're on a PR campaign to say that Trooper Proctor is an asshole. I don't know. If anyone watched the first trial, then they might have already walked away with that opinion. But the argument is that the defense is strategically placing things in the public to taint the jury pool. If that information was sealed, it should have been redacted in the motion. I don't disagree with him that the text message in the motion, let me just pull the motion up real quick. Let me read you the exact text. I don't disagree with him when he says that the text message that we're talking about doesn't follow the argument that the defense makes. And I criticize that when the defense filed the underlying motion before the motion for sanctions came in because it was tenuous. Does that mean anything's going to happen with this? Not necessarily, but he wants to complain about it before the court and say, Your Honor, see, they're doing all this shit. So let me find this sanctions motion real quick. I didn't have it pulled up, which is on me, but it should be, where is it? If she had given the docket number, it would be a little bit easier. Fred, I'm not talking to you, Kat. I'm trying to find this motion. I'm going to let him argue while I look for this. He is taking, and both sides have done this, the through line that is true and extrapolating it, which is a lot.
It is saturating the public with sometimes disinformation.
The public is already saturated on this case.
That inevitably is going to make a juror's job much more harder.
It's going to make it hard to find a jury at this
It's unfair to
point.
the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors.
Can you focus on it violating the
And
court
so,
order?
not only is there not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We did turn it over as a text message, and notice of discovery 51, a protective order was issued, number docket 416. We produced it, notice of discovery 57.
I grabbed the filing. So sorry I didn't make that big. As you're staring at my face looking for the filing, my apologies on that because I had a different window open. Commonwealth motion to impose sanctions. The sanction that they are asking for is regarding a text message from Trooper Proctor that the defense put in. Did they even quote the full text? No, they didn't quote the whole thing. Well, I found their motion, but they didn't quote the whole thing. All right, Brennan, keep going. I'm going to look for the other one.
And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems
Everything in
that
this
was
case.
the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements.
I'm going to read the quote since I pulled up the defense motion. This was the defense motion to reconsider reciprocal discovery, which is where they were talking about the witnesses to the best of my memory. Oh, it just jumped. Hold on. We're going to let him argue. Emily, stop interrupting.
And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint.
We knew we were getting there today, didn't we?
The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The defense has not only trampled over 3.6.
Because Brennan's a defense attorney, so he's used to arguing about what the government's doing.
They've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're
This isn't
aware
in
of
your
today's hearing in
motion.
Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they
This wasn't in his motion.
implied.
Where was that made? Where was the January 18th?
It's not in his motion, Your Honor.
Where was that made?
That was made by Mr. Yannetti, and I have a
This
clip
isn't
of
in the
it.
motion.
He
Does this constantly. He puts things in the motion and then uses it as a shoehorn to get into a whole bunch of stuff that's not in the motion, where the defense is like, well, we have your motion and now you've got a binder full of other shit that you want to address that's not in your motion. That kind of sandbagging is BS. The text message that he is alluding to, now that I have it exactly pulled up, was in the defense motion to reconsider the court's order on reciprocal discovery. And one of the things that the defense was arguing is whether or not the witnesses or a witness had violated the sequestration order at trial, which does not apply to closing. And the defense says, quote, on July 1st, 2024 at 5:48:21 p.m., prosecution witness Trooper Michael Proctor sent a text message to ADA Adam Lally and stated, quote, yeah, didn't watch asshole Jackson's closing for good reason. Like all of us, the anticipation and anxiety of verdict has us all on edge. And when I read this at the time, I said, they're putting that in there to continue to flame Proctor because A, he can watch the closing if he wants to, and B, I think they just wanted to put out that he's calling Jackson an asshole. But I would like to see Brennan focus on just that. If that text message is protected, it should have been redacted. It shouldn't have just been thrown into the motion. Is it the most consequential thing ever? No. But he's shoehorning it with a stack of other things he's frustrated with. If the defense is violating protective orders, it's a problem. If that violated the protective order, then it should be acknowledged, and the motion can be redacted. It can be impounded on the record and then have a public redaction. There are ways to fix it, but all of those texts were impounded. It should have just been redacted out.
He also appeared on court
That's
TV
it.
with Miss Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain.
And now we're getting
The
into
Commonwealth wants to
everything
keep the
else.
remainder of the letters hidden because the letters contain.
Kellen asked, why would that text need to be protected? All of the things turned over were subject to a protective order. So there was a whole dump of a cell phone that was under protective order, which is not uncommon. If a cell phone is being turned over, that's under protective order in a high profile case like this. That doesn't surprise me. So the entire distribution was under protective order, but he's moved into a complete different lane of argument, which is the type of sandbagging that led us to court getting stopped 2 weeks ago. And I would like to see the court say to him, where is this in your motion? Where is this in your motion? It's not, then we're not arguing it today. I would like to see the court cut him off at this point.
Information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is,
When was that court TV appearance?
I can get the date for Your Honor.
Hey, Your Honor, you'd have it if he put it in his fucking motion. But he didn't, so of course you don't have it.
Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion.
That's
And
disingenuous.
this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office.
Oh, really?
And let me make crystal clear.
Oh, I want to know exactly what you're going to make crystal clear. However, with regard to the Birchmore case, there are witnesses in common between these two cases, and that discovery is clearly in bounds. There are common witnesses, just like any case Trooper Proctor is attached to. Discovery from this case regarding Trooper Proctor's behavior is discoverable in those cases where the witnesses are in common. It's completely relevant.
They made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters.
So it's over.
It is closed.
So it's over. I had been waiting to see if there was going to be official word. And there it is. We were told last week that he was going to say this in court. How did the media know last week that Brennan was going to talk about the federal investigation in court? How did anyone know what he was going to say? I wonder how the media knew that Brennan would say in court that the federal investigation was over. All right, I'm going to back this up because I did want to hear it from official sources. And he says the U.S. Attorney's Office called him.
Karen Reed. This is,
When was that court
So I've
convened?
backed up.
I can get the date for Your Honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so
Wow.
I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading...
It's a fucking text message. Everyone said it was a text message. How are you saying it's a private email if it's a text message? But we now have seeming confirmation that the federal investigation into this case and into the death of John O'Keefe is closed. We had seen leaks, but where did those leaks come from?
for the world to see. It's just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear
Audio clips under seal.
why this is happening. And so, inevitably,
This is speculation from me. I wonder if the audio clips under seal are from one of the interviews that Karen Reed was giving. And when I say these interviews can hurt, if she is having a conversation with her attorneys, with a reporter saying we need people to understand, we need the public to understand, the court might not take it well depending on the context.
the court has the
But
ability
we don't
to
have the
sanction.
context.
And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance.
When
They
did that
can't
happen?
be. Doesn't matter who you are.
Did that happen?
And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings
asking
submitted
for-
by the defense should be under seal so the court and
Wow.
the Commonwealth can review them and make
That's-
any objections if there's any material that's private, so that there's no
Wild.
oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can
He didn't ask for all motions filed under seal. He said all defense motions.
be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact. There should be a gag order on all of these attorneys, every single one of them. And the Commonwealth will not speak either.
Should be a gag order.
Ms. Reed, I'm not asking for a gag order for.
Well, you don't really
And
have
so in light of
the ability to
history
put a
of
gag
these
order on her.
repeated violations,
Wow.
in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this case, is to impose those sanctions, and that's what I'm asking for. Thank you.
I need to pause right here real quick because I need to look at the motion for sanctions and see what remedy they asked for, because I think that went well beyond what the Commonwealth had asked for in their motion for sanctions. So I'm just going to grab it real quick. This is from February 14th. The Commonwealth moves that defense be sanctioned. I'm quoting from the end of their motion for sanctions from February 14th, to include but not limited to being ordered to file all motions under seal and impounded. Okay, that was in there. Until such a time that both the Commonwealth and court can ensure the filings comply with all previous orders. The content of improperly filed motions serves to taint the prospective jury pool. So they had asked for the sanctions and the under seal. They had not asked for the full gag order. Wow. Well, today just continues to go off the rails, doesn't it?
Arguing this, you said?
Yes, Your Honor. May we approach, please?
Okay.
Oh, well, it sounds like the federal investigation is over and they are approaching. They are approaching at sidebar. So I'm going to zoom through this because we did leave ourselves zoom room. I think at some point we're going to bump up against lunch. But I'm interested to hear what Yannetti has to say. So
As I mentioned at sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful.
Right, it should have
been. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony.
I appreciate that Yannetti has not come in swinging, because he should have redacted that out, and he knows that he should have redacted it out. But Yannetti's coming in calm because he has to explain/apologize for what was not redacted out of the motion, and then try to take the sting out of the rest of what the Commonwealth has said. This is not an easy thing to do in court when you're being attacked. It's really hard to take a breath and then say, that was an oversight. There's a lot going on in this case. It should have been impounded, and it was my mistake, and it shouldn't have happened. So instead of coming back with the Commonwealth is sandbagging us by putting a bunch of stuff in their argument that wasn't in their motion, I appreciate Yannetti's approach. I wanted to point out that it's not easy. Also, he's the defense is not in good footing with the court at the moment because we have issues with statements about ARCCA and we have issues with stuff not being impounded. So these are not insignificant when they come together on the same day. It makes it hard because the defense is like, we shouldn't have done this. We shouldn't have done this. We shouldn't have done that. The way that Brennan doubled down on that, though, is wild, given what we've seen from the Commonwealth, too. So it's a lot. But remember, the things that have been the largest issues for the Commonwealth are discovery issues, from my perspective. Discovery issues are the biggest issue. And right now, these defense issues are issues between the defense and the court. Representations of the court's order. So it is different than discovery issues. All right. I'm interested to hear what else Yannetti has to say.
Testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply with the court's
I
protective
liked
order.
that one way
That's
less.
evidence that I did not intend to violate the protective order.
That one pissed me off more than the text from Proctor, because that testimony was, some of that testimony was impounded.
And that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him.
But you
and I
didn't
was
correct it to the
transparent with
court.
him about what had happened.
But you didn't
and
correct it
so
with the court.
We get to the issue of whether sanctions are appropriate, and I recognize the court's discretion in this regard.
You should have withdrawn it.
In this,
And
with regard to
redacted
this
it.
issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial.
No one was shocked. No one was shocked that Proctor called Jackson an asshole. Literally no one. None at all. Zero shock.
Opinions about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it was certainly not an instance where I, flagrantly revealed or even inadvertently
struck a
revealed
very
Social Security numbers,
appropriate
addresses,
tone
dates
with
of
this.
birth, private information to that effect.
I don't know if it's going to help.
As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety.
It doesn't shock
At all times
anyone.
during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information.
I mean, he definitely called Karen Reed a whole bunch of things, including the see you next Tuesday. So and he called Yannetti an asshole and probably other things that I'm not remembering. So does Proctor's name calling of the defense team undermine anything? Probably not. Probably not. And also not shocking.
Coming to light in this motion, that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety.
He thinks
at
we're
all.
all
And finally,
assholes.
with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by
He has
the
a full
protective
apology
order
written
that this
out.
communication brought by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were
She
laid
might
out
put a
by the
gag order on this
Commonwealth and
case for the
discussed
next
by me
month.
here.
She really might.
And as well as whether there is a degree of prejudice.
I don't think it's gonna
that
help
would
at this
warrant
point,
a
but-
sanction. Thank you.
Do you want to address the disclosure of grand jury minutes?
There was a lot of contrition in his statement to the court, and I think he struck a good tone with it. But the defense has had some errors in this that are not going to be well taken by the court, again, because the defense errors go directly between the defense and the court, not between the defense and the Commonwealth. These are not discovery issues. These are court order issues. And the court is going to treat that differently. And it's not just this judge. A lot of judges would. So I'm not surprised by that. All right, let's continue. I mean, I don't know what code I'm at. I don't know what code I'm at right now. I'm just like, I don't know where we're at today.
I'm prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
I did, and I do have concerns about my ongoing obligations, so perhaps.
I'm curious about what from the grand jury they think was disclosed. That white noise is from the court. I'm going to zoom and see where we get, because they are going back to sidebar with regard to the motion for sanctions. There is still the issue of the motion to dismiss that we haven't taken up today. Good Lord, today is going to be a lot. All right, let's zoom this and see what happens when we resume back in court. Oh, they've changed angles on the fan. All right, we are getting back to court from the only fan. Let's go back to court, shall we? I'm trying not to over and or under correct, which is constantly a problem because live streaming is dynamic. This freaking fan.
All right, Mr. Yannetti, go right ahead.
Thank you, Your Honor, and thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in
So the argument was made at sidebar instead of kicking everyone out of the courtroom and letting them back in. That's how the court has done it. Sidebars are all impounded and under sealed. So there is more argument there. Let's continue.
We did that because that was material that needed to be done at sidebar.
Oh, I understand, Judge. No, and I'm
I just want
thinking,
the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it.
I'm pausing this because I want the date of that. So I'm going to back up just a little bit for the date. Looks like a letter from the U.S. Attorney's Office. Sorry, chat, to drag you with me, but I'm very curious about the date of that, and I missed it.
And I'm
I just
thinking,
want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well.
It is.
Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the First Assistant U.S. Attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and
on January 30th.
Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement?
Oh, boy.
And what was the date that you all found out?
No. The Commonwealth is the one throwing this around. Make them line out the timeline. The Commonwealth has said Attorney Little made this representation in court. When? They didn't put it in their motion.
About what Mr. Brennan just announced in court.
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr.
We all want to know
Brennan
that.
called me to inform me of that. I don't remember the date. Maybe, perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. So just in closing, Judge.
If the defense had been given that information before, then it's an issue. If they hadn't been given that information before, then it's not their issue. When the Commonwealth, if the Commonwealth was told before and didn't tell the defense and the AUSAs didn't tell the defense, that's not on them.
This was not a boogeyman The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Okay. Any follow-up, Mr. Chairman?
I'm interested to hear his dates.
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th.
Did she make the statement in court again? Brennan? Did she say it again after the 19th? So after
Argument on February 18th.
you complained. Okay, I'm going to let it play.
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th.
What?
The import of the argument.
Bruh.
Am I losing my mind? Or did he not just come into court and say that Attorney Little is making an argument that there's an ongoing federal investigation when she knows that the federal investigation is over? That's what I took away from his argument. She said it the 18th in court, February 18th. He was told on February 19th and told the defense on February 26th. Chat, motion granted. Motion granted. Motion granted. Motion granted. Miguelina, you don't need to. The app is already here. I don't think we have too much left of court today, but motion granted. Because what the fuck? What the fuck? What the fuck? Chat, we're going to code red, which is our code what the fuck. Because what the fuck? And I love this bumper, but if you are flash sensitive, the flashing does stop when the music stops. We are going to code red in 3, 2, 1. My lights are going to be delayed because my app is delayed, but we'll get there. Don't worry, we'll get there. However, when we saw the timeline of Brennan's arguments laid out by Alessi last week, I think they always need to ask for Brennan's timeline. Because Brennan has burned some trust. When you stand up and say, these documents were given me to the federal government, and then you get back up and say, just kidding, these documents were given to me by the defense, and then you get up and argue the defense was telling this court there was an investigation that wasn't ongoing at a time when they didn't know it was no longer ongoing. You've burned being taken at your word at this point for me. I need the receipts on all of it. Bring receipts or stop talking at this point. I'm so put out. It's such... Okay. On the 26th. And told the defense on the 26th. That's a week? Okay. What? Not what?
Is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety.
That's not what you seemed to argue.
It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now
it's not the argument
that
you
case is
made.
closed.
I may just briefly respond, Judge.
That's not what you said, though, bro.
A particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
That's also fair.
Under the umbrella of the rules of professional responsibility.
Correct.
Court TV was not in the courtroom.
Ugh. Sit down. Yeah.
Okay. Thank you. So what I'd like to do now, there are new motions that were really just filed. And what I'd like to do, I have one that has a response. So it's the motion to amend the scheduling order to give the defendant a little bit more time.
I very much want to hear about this.
To dismiss and the Commonwealth's opposition. I would like to hear that now.
I would too.
The parties have any problem hearing that motion now? It is a
No, Your Honor, I think it's very brief.
All right, so I need 1 minute, Mr. Jackson.
The court is a little hard to hear. The court has moved to asking the defense about the newer motions filed. We have finished the motions that were docketed before, except for the motion to dismiss. The defense is asked to continue the motion to dismiss argument so that they can file a supplemental. And I went over that in the Emily show on Monday that was released. So if you haven't caught up with that, that might be why you're like, wait, what? I would be surprised if the court does not allow them more time to argue this. This was supposed to be argued today, or tomorrow or Friday if needed. So we will see on that motion to dismiss. But I think she should give the defense more time based on their representation. So let's see what we're at now. Let's see where we're at now. So, today's been wild. That was a whole situation. Jackson, are you arguing?
I have to check. All right, so you're both prepared to argue this motion?
There's so much background noise.
In the opposition?
I'm so sorry.
So both sides are prepared to argue this, the motion to amend the court scheduling order?
Yes.
And the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition and just informed defense counsel if they're looking for a date this week if the court's available. I just don't want this to linger because.
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I speak with counsel?
So the court has said the 17th is pushing too far. Brennan has said you'll get a few more days without opposition from us.
Yes, Your Honor.
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G.I.A.M. Pietro, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of Sallyport videos, and then about another 15 actual videos. I basically...
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Does anyone on the defense team look different?
I know Ms. Little was...
Yeah, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court that I've gone through it in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sallyport garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something in connection with C, or is it blurred in?
I think some of them are at least the same ones. Some of them I think
She
are
doesn't
blurry. I
know.
haven't watched them all in detail. I can tell you.
They came in last night at 9 p.m. She doesn't know.
That they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing
Really?
anything on the
So what
table.
I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just wanted to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, or I assume it was Ms. Little's motion to filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue that
I have not looked at them, Attorney Lally did, and he represented that they're all the videos we've already turned over, same quality as we previously provided.
So it's
They're just copies
duplicative?
of the same videos, although I do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting them, we passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do. I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sallyport video and related evidence, that has to be filed by Thursday with the idea
I
that
think
we'll
that's
have a
fair.
hearing on this on Friday. We have Friday already blocked off. This way here,
No.
I'll leave for today, and we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Mr. Yannetti after 5:30 on night. So we need things filed.
Mr. Yannetti, during court hours, this isn't federal court where the deadline's at 11:59. In local court, oftentimes, the court day deadline is like 4:35. Oh, Emily's got so much on Friday. It's okay. I'm used to other people's courts interfering. We'll figure it out.
By that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Commonwealth's response, any idea?
He's pretty
Well,
short,
argument
actually.
time,
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at
keeps his
11, we'll finish Friday?
Oh,
Comments.
of course, yes, I believe we will, for sure.
How does that schedule work for people?
It works for the Commonwealth.
I need to ask this a little one question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to just
Thank you.
go do that.
Thank you.
And not have to come back here tomorrow.
Yeah.
And I'm trying to consolidate this now so you can leave in half a day today, rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated.
Your Honor, 11 o'clock would work. I think I can make my flight. By the time we get done, I can take it to the airport. That's fine.
All right, so where do we stand in the motion for reconsideration? Sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that, obviously. We gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they had received that. There is still metadata, we believe, on the Camden PD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert put in his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need, I know this motion is just filed, how long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
I think we'll file a written response.
Okay,
We're going to be a couple of days.
okay.
And we have motions on maybe Friday.
Yes.
So I think I'll make a motion in writing, but I think we will hope to have the weekend if the court allows, because with all of these hearings, it's taken away quite a bit of our time.
All right, can you argue it on Friday and file a supplemental afterwards?
I can do that.
That way then we can have everybody here Friday and I don't need to bring everybody back Monday.
We can do that now.
Your Honor, I would ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions in limine due on Friday. I know the court would like us to have, the brief as to the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss though, right? I need to.
Well, they don't know.
So you've got these recent ones, but I need to know how that, are you going to argue that on the motion to dismiss?
Well, I don't know because we got it last night at 9:30.
They don't know until they look at
I
it.
wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant. It might not change anything at all. I won't know until I have a chance to actually go through everything.
But I need some.
What is so loud in court?
Thursday. It doesn't have to be a complete report.
Something's loud. I don't know what it is.
An outline even, would the Commonwealth be satisfied with an outline? You know what the points are?
An outline of what you are.
Of what Ms. Little says, how this late disclosure of videos.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I'll want to supplement it very quickly thereafter. I have to decide this and put something in writing. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
May I have 1 minute, Ms. Little?
You need to review the videos, though. You guys are like, sounds like a radiator. The court's like, you've got a team of lawyers. Look, scheduling in court is one of the hardest aspects of court. And they've got a lot that they have to do this
Your
week.
Honor, given what Ms. Little just said and the court's concerns, I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever. Could I ask the court, if it's okay with Mr. Brennan, we can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings.
Oh, we're changing again.
Let's just argue this tomorrow. I will concede.
This, what?
The motion to dismiss. I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow if that's okay with the court.
Are you waiving the additional argument that Ms. Little says? Are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation. It's true. And I don't think that we need to file a supplement, which is really where the hang-up is. I don't think we need to. If the videos are the videos, we don't need another supplement.
All right?
Huh.
Ms. Little doesn't look thrilled.
Miss Little's like, nope, 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 nope. And AJ's like, yep, 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 yep. Okay. We'll see where this goes. We'll chat. We'll talk about the federal proceedings in a
The
second.
key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay, what's the Commonwealth's position?
Okay. He's like, I was ready now.
I'll defer to the court. You know, it's more complications with the defense and travel.
Yeah, the defense's schedule's way more complicated
So I
than
think we did log off today and tomorrow.
you did.
With the understanding that the defense team would not be here until sometime 11 o'clock or later.
Okay.
What about, Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here on Friday.
If you're going to be here on Friday,
I just won't be here on Friday. So if we do the motion to dismiss tomorrow, I can head back.
Jackson wants to make his flight.
And Mr. Little will handle it's her motion anyway.
I think that's
I
fair.
greatly want to accommodate the defense as we have the entire time I've been here, but we have trial prep to do as well. And in more court hearing days, we have hours of conversation, the more time we can't meet with witnesses and prepare our case. And so I want to make things as easy as possible for the defense. I do.
all right, so Ms. Little already filed the motion for me to reconsider. Why don't we head out tomorrow as well?
Very well.
Okay,
Oh.
and we'll just finish up everything tomorrow.
Yay!
All right, and then you won't have to be here Friday, but the motions are already all filed. It also involves filling out a final conference room. So we need to do that as well. That all has to be done by Friday.
Understood.
And then, you know, my goal was not to bring you back one day at all next week, because then we're gonna have a full hearing, I believe it's the 18th, and the motions in the minute.
That's right, the 18th.
All right, so you have a whole week next week to, you and I both.
Should we file a formal motion to ask the court's permission for a delay from Friday till Monday?
No.
For the,
Motion is imminent.
No, she can just do it now.
the Commonwealths were due on, the defense were due on Thursday, Commonwealths on Friday.
Just do it now.
Were they all on Friday?
Reciprocal discovery is due Thursday. We want that to happen. Motion's eliminated, I believe, we do Friday.
Ms. Little, would you like the weekend for all those motions in the
Yes.
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you very much.
Motion's limited to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the Daubert motion for Dr. Woolf. It has not been heard yet.
A Daubert motion for,
Dr. Wolf, it's a
I haven't
neurologist.
seen that.
So there's
oh,
one
I thought you
additional.
meant, I was thinking the ARCCA.
No, Your Honor, it's the neurologist of the Commonwealth. Wolf without an E, W-O-L-F. That was filed 2 weeks ago, I believe.
I have not seen that.
Okay. I'll make sure that the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
Oh, I
The
see.
Commonwealth must have received it.
We did. We have a Wolf as well, and I received their amending motion, and we'll be prepared anytime to argue that.
Do you want to argue
Okay.
it tomorrow?
I'm comfortable arguing tomorrow.
We're prepared.
All right, so
Okay.
we've got an awful lot to fit in tomorrow.
Tomorrow's going to be busy.
All right. If you get word that you'll be leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just contact the clerk's office.
Sure, okay.
Okay.
Anything else for today then?
Not for the defense, Your Honor. Thank you.
Okay. Tomorrow's going to be busy. Don't worry, I will do a recap before we get to questions, chat. Do not fear. Scheduling is...
So I'm going to give you all why don't you fill out all the signs, I'll be out to teach you.
Court, call, please.
Scheduling is critical. The court has said, why don't you all talk? So they're all going to talk. Let's see if they come back onto the record at all. All right. Let's zoom real quick before the end of court. And it looks like we are almost done for the day. So, and then I will do a recap and we will be in court tomorrow, but we are almost done for this day.
What's back in session? You may be seated.
Don't worry, I'll do a recap. We'll talk about federal court tomorrow too.
Okay, so where do we stand? There was something you all were talking about.
All right. Everybody has met and conferred. The court gave them a break. Let's see where we're at the end of the day.
Was there anything that concerns me?
Not at all, Your Honor. I think the schedule that the court had just articulated is the schedule that we'll follow. Mr. Brennan and I have discussed it briefly. The motion to dismiss, Ms. Little's motion, which I can't remember the name of it. The motion for reconsideration, thank you. And the Daubert Woolf motion, I think we can try to compact all those in together.
So we will.
Done.
All right,
Yes.
so Mr. Leslie, are you arguing the Daubert motion?
Now the court's sounding like me. We will be done tomorrow. This shit's not happening Friday. And then she looks directly at Alessi and are like, you arguing that motion, my guy? Because you'll take as much time as I give you. She's going to be like, sir, we need to put some bumpers on that motion for your argument.
I'm arguing the Daubert motion, and I will compact it as Your Honor has just directed.
So let's finish all this tomorrow.
Understood. Thank you, Your Honor.
All right?
Let's be done tomorrow. Let's be done tomorrow. Yay. All right. Good job, everybody. Wow. Today was busy and court is done for the day. So look at that. I think being done early today and giving the attorneys time to prep for tomorrow is definitely needed. Chat, I'm going to answer all of your questions, but I'm going to do a summary first. So let's get the lights back from code. What is even happening today? And so much has happened. Emily, how are we going to summarize? I don't know. We're probably going to leave something out. I'm going to have to look at my notes and summarize again tomorrow because so much happened today. Let's see if we can get these lights to go back to what they normally do. They're fighting with me. So we might just be in code red for our summary, which maybe is appropriate. Maybe we just leave it be. All right, chat, we're going to do a summary. Then I'm going to answer your questions. Then we're done. Enough work for this day. I have empathy for the court in that scheduling with this number of attorneys that live in multiple states is not easy. So with everything trying to get scheduled, the court is trying to give everyone enough time, including the court, because the court has research to do. The court needs to go through the motions. So there is work that the court needs to do when all the attorneys are not in court. So the attorneys are probably quite tired. All right, let's try to do a summary and then we will do Q&A and then we will answer all of the things, hopefully. And then we'll take a break and then we'll take a break. That's enough for this day. And then we'll be back in court tomorrow. What I will say about tomorrow. What time is court starting tomorrow? Well, it's going to depend. So if you don't want to miss court tomorrow and if you don't want to miss court during trial, now is the time. The Lawnerd app is free. iOS and Android. I will send you notifications when court starts because the court said 11, but she also said if you get out of federal court or earlier, let us know and we'll start earlier. The court's like, I'm going to be here and ready. So court is supposed to start at 11 Eastern tomorrow, may start early. I doubt that will happen, but if it does, so will I, ish, with Zoom Room. So make sure you get the Lawnerd app at lawnerdapp.com. Look, I got to keep you in the loop. When court gets spicy, we're going to send you a notification. Let's try to do a summary of this day. Let's swoop and summary. Did I already swoop? I don't even know. Well, today in the Karen Reed case was quite a lot. It's Tuesday, March 4th, and they ran about a half day of court today. As you will remember, the defense filed their motion for a brief continuance with regard to the motion to dismiss, And it seems that with today's half day of court, that's going to be taken up tomorrow after federal court. So tomorrow around 11 a.m. Eastern is when court should begin to hear argument on the motion to dismiss, and a one more motion with regard to the Commonwealth's expert from the defense's side. And then Ms. Little has recently filed a motion to reconsider the defense's request for metadata. So those are the three things on the docket for tomorrow. The court also extended the deadline for the motions in limine. Those are going to be argued on March 18th. The motions in limine are those pre-trial motions about what evidence will come in, what evidence won't come in. So that day, the 18th, will be a full day of court arguing those motions. So those are going to be due on Monday, and then those will be argued following that. But it's what we see ahead of trial in every case. And then they're just, not even weeks out from jury selection beginning on April 1st. So all things considered, this case is on track to start jury selection April 1st. It'll probably take a week of jury selection given the publicity of this case, but it's supposed to be a shorter trial. We will see. Tomorrow in court, there is the habeas petition argument in federal court. I've covered the defense's petition. I did not have a chance to go over the Commonwealth response more thoroughly. It is very similar arguments to what we saw before the Supreme Judicial Court, but it's taking it up the federal track to say that Karen Reed's rights have been violated by the court declaring a mistrial when the court should have given the option for the jury to enter their verdicts of counts 1 and 3. But the jury did not indicate in their notes that they had verdicts on counts 1 and 3. So the manifest necessity for a mistrial is going to be the core of the defense argument. They are trying to, at a minimum, be allowed to interview the jurors about whether they reached verdicts so that Karen Reed is not retried on those 2 counts when the jury says, or at least some of the jury members say, they came back with verdicts on those counts and didn't know they could enter a partial verdict, meaning on 2 of the counts, not all 3. And that it violates Karen Reed's double jeopardy to go ahead with that retrial. We went over some of the case law that was cited by the defense in this. The Supreme Judicial Court has said that in the court's discretion, the court did not violate their discretion in finding there was a manifest necessity to declare a mistrial, that the notes from the jurors were clear, and therefore the Supreme Judicial Court in Massachusetts did not find any error in the prior ruling. They are now taking this into the federal system, and there will be argument on that tomorrow. That will not be streamed. It is open for the public on a first come, first seated in federal court there in Boston. And then all the defense attorneys will be back over in state court in front of Judge Cannone. But today, the court started off with, I have a few more questions about paying the ARCCA experts. And that included questions about Attorney Little's filing to the court that corrected the defense opposition to the Commonwealth's motion to exclude the ARCCA experts due to failure to meet the discovery obligations. And Ms. Little corrected, saying we stated in our opposition, which they did, that they did not pay the ARCCA experts. And she said, no, we in fact reimbursed them. I think they paid them. It's not really a reimbursement for fees. They paid them for their time. Again, there's not a problem in paying an expert for their time. That's not the issue. The issue is, was it represented to the court differently? And the court came out today with a bunch of questions about that, saying when the invoice from ARCCA was turned over to the defense in discovery, why wasn't the payment to ARCCA of that invoice also disclosed? And the court did not seem pleased about the fact that the payment was not disclosed, and in fact asked Attorney Alessi, and it wasn't even brought up until halfway through your presentation to the court, to which Alessi responded, Your Honor, I was going in chronological order. So in the chronology, we hadn't gotten there yet. And in fact, I didn't know that there was payment made to the ARCCA experts until Sunday before we were in court on Tuesday. But the representations of Alan Jackson at sidebar about not paying the ARCCA experts, the representation in the defense's filed motion that they did not pay the ARCCA experts really is the sticking point here, because they paid the ARCCA experts. They didn't hire them, but they did, in fact, pay them. But will this impact the ARCCA experts' testimony at trial? Unlikely. It's unlikely. They will still be allowed to testify, and then the Commonwealth will say, and have you testified before and were you paid for your time? Yes. Okay, every expert ever. They're going to ask the Commonwealth experts that, and the Commonwealth experts have been paid. So it's the issue of how and when it was represented to the court. And then we got into a extensive motion later in the morning from the Commonwealth on a motion for sanctions against the defense for violating a protective order with their motion for reconsideration, wherein they included testimony of a juvenile witness and statements made via text message between Trooper Proctor and ADA Adam Lally. When Yannetti responded to that, he said, "This was my error. These things, I didn't think they were covered by the protective order. When I went back and looked at the protective order, it's clear that they were." But Attorney Yannetti did not file with the court a correction, which I think is also going to be a problem for the court. But then the Commonwealth went way beyond their filed motion and argued that the defense has been essentially on a PR tour and that there should be a full gag order in this case. That's being taken under consideration. But in the middle of that argument, we get the Commonwealth coming in and saying that Attorney Little is talking about this, federal investigation. And then there's an implication that the elected DA Morrissey is the target of the federal investigation and that other members of the defense team had said that on television earlier on in this case, and that there isn't any longer a federal investigation. And the way he presented it, and I want to go back and watch it when I am not streaming, but the way he presented it, he seemed to indicate that Attorney Little represented to the court that the federal investigation was ongoing when she knew that it wasn't. And then we get up and go through the fucking timeline, receipts, everything. And the timeline is that Attorney Little argued that in court on February 18th. The Commonwealth was told that the federal investigation was over on February 19th. And the Commonwealth disclosed that to the defense on February 26th. So when Attorney Little stood up in court and said, and there's an ongoing federal investigation, and talked about the ongoing federal investigation, to the best of anyone's knowledge on February 18th, that was true. And I think, again, Brennan implicated that when she made that statement, it was not accurate. But then when he broke down the timeline, it was, which harkens back to the last hearing when Brennan's like, and I got all these things from the defense, or I got all these things from the federal government, and then had to come back into court and say, no, wait, those actually came from the defense. Where I have grace for there are times people misspeak in court, when it starts to become the pattern of speaking in court, I start to have greater concerns. So I want to see the receipts, the timelines, everything, because the impression that I was left with listening to this in real time was that somehow the defense had represented something wrongly. And what we've seen over the last few weeks is that the defense has had to correct themselves a number of times because they have represented things to the court. We have not seen the defense file for motions against the Commonwealth for the same. And those seem to be corrected in court in real time, but they're still getting corrected. And it's an issue that this has gotten so wild with the way things are being alleged in court. And I don't think it's going to tone down before trial. This seems like the retrial is going to be a trial where we have objections during opening statements, closing arguments, and all the rest of it. It is going to be hard fought. And it's going to be difficult, I think, for the attorneys to have, at some point, some type of collegiality. So what we learned, though, is that the federal investigation is over. We have seen that there's been no indictments, so it means there are not going to be any indictments. And the federal investigation into whatever they were investigating with the Karen Reed case is done. So now where do we go? Well, we go to a retrial. and the ARCCA witnesses aren't as restrained, but the jury is still potentially going to have to grapple with, well, in this prior proceeding, in that prior proceeding, because when we get to this second trial, which I think we will, when we get to this second trial, there are witness statements to law enforcement, to a state level grand jury, to a federal grand jury during the first trial. And that's if there's only one statement to law enforcement. So we have witnesses that are going to come into this who have testified at possibly 3 prior proceedings, plus given statements. It is going to get messy. And we're going to see a lot of in prior proceeding on this date, didn't you say? Buckle up. There's going to be a lot that's going to happen in court between now and the beginning of April when this case starts. And I'm going to try to keep you in the loop on all of it. But it looks like this trial is going to go ahead. And I will be surprised truly if it doesn't. I think there are considerations in the motion to dismiss. I also think the case law is a very, very high burden to meet for the defense, which I broke down on this week's Emily show. So, law nerds, let's get to your questions, shall we? Shall we get to your questions? You've got them. Hopefully I've got answers. I'll tell you if I don't. But we should get to questions. I saw a number of questions, and I imagine they weren't all from the same law nerd because there's over 21,000 of you here. Also, if you haven't done the YouTube things, do the YouTube things. We've got trials. We've got this. We've got Corey Richins. At some point, I think we're going to have Donna Adelson over the summer, and then we're going to Idaho for the rest of the summer into the fall. But with the feds, a lot of you asked, were the feds fired? The feds opened their own investigation. So the U.S. Attorney's Office and the FBI, oh, Emily, it's been a minute, opened an investigation. What they opened it into, we don't know. What we do know is that in the Birchmore case, the feds brought charges against a member of law enforcement. We know that in that case, there were some witnesses in common with this case. And we know that case resulted in a federal indictment. And this case has resulted in no federal indictments. It doesn't change the federal protective orders. It doesn't change what's under federal protective order. It's just done. That's it. There will be nothing else. A lot of you have asked, when will there be a ruling on Betterow? There is no ruling pending on that because no affidavit has been filed. The court said that they will rule on the pro hoc vice, which is the can I come appear in this case for this only. The court said that they will not rule on that until an affidavit is filed by Yannetti. I have not seen that on the docket. So until it's on the docket, it's not going to be ruled on because the court doesn't have it. What the court is pending on right now is the motion with regard to the Commonwealth's neurologist, the motion to dismiss, and the motion to reconsider, those 3. So those are the ones that we need to see. So we now know that the federal case is closed. Synod said, Emily, reporters have asked the feds if it's closed and they have no comment. The feds will never comment on an investigation. They will never comment on an investigation. They do not. They do not. So they will only comment on an unsealed indictment. The fact that Brennan represented that in open court with a letter and the defense said that they were told is the most confirmation we are going to get. That is it. That is the official word because they got a letter. The court will have that. The defense did not contend what the Commonwealth said. So that is as true of a fact as we are going to know. But yeah, the feds will never comment on it ever. So Brittany said, if they don't comment on it, how does Brennan know? Oh, the feds disclosed it to Brennan and Brennan disclosed it to law enforcement, but the feds aren't going to say that to the public. They had to tell the attorneys involved, but they do not tell reporters or members of the public. You probably won't even get that with a FOIA request because it'll be sealed. So no, we're not going to hear anything else about the feds. How do we know how do we not know there will be indictments? We know that there will not be indictments because if there were indictments, the investigation would still be open and there would be indictments. The fact that they have confirmed to the attorneys in this case that are intertwined with that case that it's closed means that there are no indictments coming. That's it. How do we know that they disclosed it to him? He had the letter and Yannetti had the letter on the podium as well. So we know that they disclosed it to him because both attorneys stated that that was true on the record and they owe a duty of candor to the court. And if that's not true, then they both would have misrepresented things to the court, which I don't see happening. This is not the type of thing that you would misspeak about. And both attorneys verified that that was true. Settley said, can the feds still indict now that they closed the investigation? They will not. Once the investigation is closed, it's because they are done. This case is closed. If something changes, the investigation can be reopened and an indictment can flow from that. But at this point, no, there's not going to be an indictment unless there is new or different information and then a reopening of an investigation and then and then there can be, but there's not going to be. There were 2 letters. The insane eraser said there was a letter saying it was still ongoing on the 30th. Yes. And then on the 19th, it was made clear, either a call or a letter, I will go back and take a look, that the investigation was closed. So it is closed. But do we know the full target of the federal investigation? No, we don't. But we do know that on the 30th, they said it was ongoing. And then on February 19th, they let the defense know that the investigation was done. And the defense forwarded that information to the Commonwealth forwarded that to the defense on the 26th. So with the letter that both Hank and Yannetti were holding, I think that even if that letter didn't come in on the 19th, before the defense was told on the 26th, there would have been a letter there. So it is done. But even if the 19th was a call, chat, with what both of them were holding in court, I imagine that there was a subsequent follow-up, and that's why the defense was told the 26th. So we will see. But yeah, there's nothing more that's going to happen with that. So it's done. So why would the Fed send a letter saying it's still open, including a letter directly to defense? But closes just a call with Brennan? It's suspicious. LH, I don't think it's suspicious, and here's why. We don't have the context for what was going on January 30th, but from everything we know in court, the defense needed to know from the feds what they can do vis-a-vis the ARCCA experts and whether or not the ARCCA experts were still part of an ongoing investigation, not part of an ongoing investigation. So the defense needed to know that vis-a-vis the ARCCA experts. And if that investigation was still ongoing on the 30th, the defense needs to know that. It doesn't mean that things don't change within weeks. So it's not surprising to me. And I imagine that there is a letter after the phone call that it was done. But given the fact that this case is speeding towards trial, it doesn't surprise me that there is a phone call, I would imagine, followed up by a letter. So that doesn't surprise me. And it doesn't surprise me. It doesn't surprise me. So the conversation in January, I imagine, was regarding experts and the protective order. The conversation in February doesn't surprise me that it was about it being closed. So that. Hank said he got a call, no letter, defense never got anything. He notified defense, and I imagine that there would have been a letter at some point where he notified defense. I would suspect that's why it took a week later, again, based on what Yannetti is holding. Lovely said, so now can the jury be allowed to know about the FBI, the investigation, and the crash daddies hired by the FBI? No, it's still under protective order. And it's unduly prejudicial, so it's still going to be a prior investigation. So that's it. It's going to be a prior investigation is all they're going to be allowed to say. So I'm sure that is unsatisfactory, but that is the answer. As unsatisfactory as it might be. Zeke TXNP said, so no evidentiary hearing. Well, not necessarily, because the evidentiary hearing that's pending, there's 2 requests for evidentiary hearing pending right now. One request is regarding the motion to dismiss, and one request is regarding a Daubert hearing on a defense or on a Commonwealth expert. So there could still be, that hasn't been ruled on yet. Could there still be a sealed federal indictment, Joe Jersey? If there was still a sealed federal indictment, the investigation would not be closed. So, no. As long as there's an indictment open, investigation is ongoing and will remain ongoing until there is a conviction. So, Chronic Shocks Art Journal said, EDB, you deserve some overtime pay for this last week. It's been busy. Also, did you see the Doctor Who trailer with Alan Cumming voice reveal? I did not see it other than what Law Nerds had tagged me in, but I've seen clips of it. I haven't gone and seen the entire thing. It's been incredibly busy over here. Truly. Music to My Soul said the judge needs to accept that there's too much left to do to start the jury April 1st. Don't rush the important motions. Oh no, it's going to happen. And I don't, attorneys amazingly find time to get things done when there are deadlines looming, and amazingly don't get things done when there aren't deadlines looming. This date has been set for quite a while. This is always the rush to trial, not just this case, every case, because attorneys have an order of priority just like I do. You'll see that we've got a lot more coverage and a lot more conversation of Karen Reed because it's so close to trial, vis-a-vis like Justin Baldoni and Blake Lively, because it is not even a whiff near trial. And so when you're looking at what takes priority, the closer to trial you are, the more priority it gets. And that's true for the lawyers working on this. The closer to trial that you get, the more full attention. All of these lawyers have other cases. All of them have other focus. And the thing is, the closer you get to trial, the focus kind of narrows and things will get done. They will. It feels like a rush, but the defense and the court and the Commonwealth on that have worked pretty well together. The court's like, do y'all need the weekend to get the motions in limine completed? Fine, we'll give you the weekend. Which means the defense will have essentially Thursday, Friday, Saturday, Sunday, or Attorney Little will have Thursday, Friday, Saturday, Sunday to get the motions in limine done instead of having to have them done Thursday, which gives them a little bit more time. So they've been trying to get it done. But again, when it comes to trial, it all manages to get done. This is also a retrial. There shouldn't be this much new shit. There's normally not this much new shit, but there's so much new shit. So much new shit. Big Dyslexic Energy asks, shouldn't the judge be addressing Brennan's misrepresentations? So far, those aren't subject to a motion. So the court's focusing on the motions in front of the court. And those motions have been brought by the Commonwealth. Alessi pointed them out quite loudly, but the motions right now aren't focused on it. And the court is addressing the motions and seems to be keeping with the motions, which I understand is also unsatisfactory. Charlie Wilson, good to see you in the chat, said, thank you for being my favorite law professor. That is a huge compliment, as I know you have had many other law professors. It's good to see you. I hope everything is going well down under. Evie Lexi said, can we give a gag order to the state only? No, you can't. But all the lawyers, yes, they can. TCP also asked, can they now say ARCCA came from the FBI? The FBI? Sadly, no. Why doesn't the Commonwealth get sanctions? No one has asked to sanction the Commonwealth. I don't know if the defense is going to get sanctioned on that motion for sanctions either, but I'm interested to see what's going to happen with the ARCCA motion and the discovery there. So I'm very interested. I'm very interested. Casey Cat has the same thing. Where's Brennan's sanctions? The defense has not made a sanctions motion. They've pointed it out in the motion to dismiss. And I think tomorrow we're going to hear more argument about that in the motion to dismiss. We're going to hear more about Brennan and if it's good faith and if it's not good faith. We will hear about it, but it's going to come up more tomorrow. The dash in between, Matt Bond, good to see you. I have a code red too. Love my smart lights. I know we all went code red. Code the fuck. I mean, today was a lot. Yulin said, a great day when rolling with the homies. I love the shout out, not just to the music, but also to Clueless. Amanda Scott said, would Proctor's text be protected by free speech? I mean, you're allowed to call somebody an asshole, but they're protected by a protective order because they've been turned over in court discovery. So the defense can't just put them in a motion when they're protected by a protective order, which is why Yannetti said, my bad, I'm not going to do it. My bad, I'm not going to do it. The defense has had a few my bad moments. I know the focus has been on Brennan, but the defense has had their moments, and the court is not going to be happy with violations of court protective orders. The court's not going to be happy with it. The Commonwealth discovery stuff should be equally as infuriating. Really should be. And maybe we'll see it. But discovery violations and violations of court order are clearly not hitting the same. It's actually Ashley, good to see you. Thank you for the super chat, which says, Emily, your content gave me the confidence to handle my child support modification. Good for you. Court was intimidating, but you made it manageable. Court can be intimidating, but also should be there to help. I rocked my hearing last week. What you do truly changes lives. It's changed mine. Ashley, this community has changed mine as well. I'm glad to hear it. Look, court, everyone in court is human. And we should see a system, we don't always, but we should see a system that treats humans like humans, that is not so intimidating you can't advocate for yourself. But there is always going to be a level of court intimidation, so you don't have a defendant building a box fort and derailing court for 3 hours while a jury is missing work and just sitting there. And it's very frustrating. Very, very frustrating. So yeah, court has to balance that level of appropriateness and accessibility. Family law court's a whole different ball of wax. Ms. Kruger said 18 months flew by. It's going to this year too. So Amelia said, why should we trust Brennan's FBI declaration with his usual lack of paperwork? Could there be a backlash with a filed statement? The defense seems to agree. And if the defense and the Commonwealth is on the same page, I'm not going to sit here and disagree. So, I'm not going to sit here and disagree. It's all going to be under protective order. So we're not going to know. And it's all going to be under a protective order. So even if there was an investigation, you can't even really FOIA it because it's going to be under seal. So it's going to be unknown to us. Courtney, thank you for the 5 gifted memberships. I know B2 had gifted memberships. Welcome to all the new members. I know that Lyndon had gifted memberships. Thank you. So for all of you that gifted memberships today, I appreciate it. Alice as well. Thank you, Lawnards. I see all your lovely member chats. Let's see. Janelle said, I have a meeting later this morning with the Deputy DA in Mesa County, Colorado. Please keep me in your prayers and stay classy and strong for my brother. You've got this. Also, you're human. You're allowed to human. People understand that it is not always easy. Most people do not want to be sitting across from a district attorney and having to chat with them about anything. It is not easy. And I think that good DAs should make it less intimidating, but it's also just the nature of the job. That when you have that title, people are just like I get it. Malleus said, but doesn't it seem she's gearing up to take action on this? She hasn't yet, and there's no guarantee she will apply similar action to the prosecution. The court is not happy about the representations about the ARCCA experts. The court is not happy at all. And there also isn't a ton that the court can do. So I don't see it being an appropriate remedy to, and again, I am not a judge in Massachusetts, but to remove one of the defense attorney at this late stage is going to be a shit show and just an automatic, like, no. Removing the experts isn't a proportional remedy. The discovery has since been turned over to the Commonwealth, which fixes the discovery issue. It's since been explained to the court on the record. So really sanctions and sanctioning the defense monetarily, they'll be like, okay, we'll pay the sanctions. So sanctions seem like the most likely thing if there is a thing. Cheryl Ray said the jury will never know any of this, correct? They shouldn't. I mean, they shouldn't. This will never come up in trial. All of this pre-trial stuff will not come up at trial and should not come up at trial. But get out your checkbook isn't the most unreasonable thing. However, if the court finds that it was an error and not intentional, the court can say, I find that these representations were made by the defense. I do not find they were willful misrepresentations. The discovery has since been turned over. It can be cross-examined on. The court can make findings that it was said and also find that it was not a willful violation. So we will see. We'll see what happens. We'll also see if we get an expert to testify about how hard the ground is. Like the court has a lot of rulings to write. They're all going to come in the week that I'm on vacation with my kids for spring break. They're all going to come in there. So let's see. Tiffany says, fun fact, Scotty doesn't know Singer was played by Matt Damon. We know. Oh, we know. Oh, Tiffany, we know. We 100% know. It was the end of the members only behind the scenes recording of the podcast this week was Scotty doesn't know. And I will let you all know, I did A, make it to my kids competition with plenty of time. B, they were fantastic. C, they moved up a division and still came in third. So all things went well this weekend and it was fantastic. Lyndon, thank you for the gifted memberships. Carol asked, is the woman who Chloe attacked going to testify? Unlikely. Like very unlikely. It would very unlikely. Mildred said, I want to see the chain of custody for John O'Keefe's clothing. Same. I would like to as well. Lordy in the chat said, love my pin number 2, just received at EDB. Oh, I think I still have one on my desk. I love these. I love them so much. I have a bunch of these because I put them in different places. But for those of you that are like, Emily, what's back on your chair? They are our little spicy skull Lawnard pins for our Lawnard drop number 2 from the Lawnard shop. I think most things are sold out. I think we still have stickers. Hold on. Do I have a sticker pack on my desk? I do. I have an open sticker pack and an unopened sticker pack, but I think we still have sticker packs in there as well. For those of you that live abroad, the state of the world is going to make some of the shipping hard. But for those of you in the United States, our Lawnard sticker packs are in there. We've got the skull is in the sticker packs, amongst other things, but the skull is in the sticker pack, which I love. These are still up on Lawnard Shop. We got our facts sticker. We got our I have questions sticker. I dropped something, so we're going to miss it. We've got our Lawnard's Rock sticker. I'm going to leave a few surprises. We got our unicorn back there. So stickers are in the Lawnard Shop. I dropped our Lawnard Love sticker, but we will have another drop, but it's not going to be next month. So we are still working on making sure that with our merch, we can adequately supply the Lawnards and deal with some international shipping challenges. And we are working on some custom merch for the end of the year. All of you have asked. We're working on it. So do not worry with that. Let's see. We're going to get to a few more questions and then we are going to go because we're going to have a long day in court tomorrow and I've got to get ready for company. So we gotta do the things. Hannah said Alessi is putting on his thesis advisor hat. It sounded like it. He was like, look, methodology. I like the way Alessi argues. So Danielle said, any chance we can get iron-on transfer or patches in one of the next merch drops to be able to DIY some Law Nerd gear? Well, we've read it out loud, Danielle, so Team Baker now knows. It's been something we've discussed. NJ Kathy said, how is eliminating the defense expert giving Karen a fair trial? I don't think they're going to be eliminating the defense expert. It was a discovery issue. The discovery's been turned over. The Commonwealth isn't asking to eliminate the experts at this point, really. They're saying we want discovery, and the discovery's been turned over. So I don't think we will be eliminating the defense experts at this point. So I think we will see the ARCCA experts testifying. Beauty and Beagles, I'm so sorry for the loss of a pet. It is a uniquely devastating kind of grief, losing a pet. It is absolutely heartbreaking. So I'm sorry. I'm glad you're here with the Law Nerds and all of today. Julian said, Emily, if the judge lets the experts' testimony in, does that open the door for the ARCCA experts to talk about it too? I would think so. I mean, I don't see how you couldn't. So I don't know. Happy at Heart said, can she go back on the requirements? Not if they're based in case law. She can't. But we'll have to see, because I've got question. Certified weather guy, certified tested soil. It's so good. I see you guys asking, when is the fax hat back? I don't know yet. We are sourcing. So we have started sourcing our goods custom. So it depends on sourcing. So I do not have an answer for you yet, but you guys know I'll tell you when we know. And Redondo Beach, you know that the members know first. So do not worry. We did not anticipate the high need for the fax hats. So they will be re-released. I do not know when, but it's not going to just pop up in the store. I will give you guys heads up about it. We're not just going to surprise everybody. So do not worry about that. The Heliopinos, I think I pronounced that probably terribly, and I apologize. Can Karen Reed offer a $100K reward for a whistleblower with evidence? Probably not at this point. I don't know if that would be advisable with pending trial, but down the road, I don't know if anything would forestall it down the road. Then again, if there were whistleblowers that were, that had inside information without a reward, they could always go forward to the defense attorneys. I'm sure people reach out to the defense all the time, just like they reach out to the Commonwealth all the time. The internet has a lot of theories, thoughts, and they share them into the email box, into the voicemail. And when they do, the Commonwealth turns those over. And we saw the last discovery disclosure from the Commonwealth. I think a lot of that discovery disclosure had things that the Commonwealth receives, people asking, talking about the case, to send them right along. So it's quite a lot. Dotterina said, I am sitting on a county probable cause grand jury learning all sorts of ways people crime. Thanks for the insights. Oh, the criming is fascinating. What's interesting to me is that there are some really specific patterns in crime. And it's always curious to me how people come into possession of the knowledge of the patterns. And then you look at it and you're like, yep, no, that's what happens. And you see cases all over the place and you're like, how is it all just happening the same way? It's wild, but it is, working within the criminal justice system is fascinating and sometimes frustrating. Well, often frustrating and fascinating. But it is much. Declan asked a great question in the chat. Even if the federal investigation into this investigation is over, the Birchmore stuff is still discoverable. Yes, the federal investigation being done and discovery on the witnesses in common are not mutually exclusive. So discovery is still discovery, even with the investigation closed. It just means that we're probably not going to get to the federal investigation upending the apple cart with an indictment. Could they reopen it down the road? Yes, they could. But is it done for now? Yes, it is. And does that indicate to me that there is not going to be an indictment? Yes, it does. Yes, it does. Amanda Scott says, what happens when a lawyer gets sanctions? They pay however much the sanctions are. It's a monetary fine. Sometimes you have to report yourself to the state bar. Sometimes you don't. It just depends on the amount of the sanctions. But you pay a fine to the court. It is like you pay the penalty. And that's it. So if there is wild fuckery, then there can be a state bar investigation. We have not gotten to the point where I'm looking at this going, oh, the bar is going to be interested in this. We're not there by any means. Now, could there be stuff I don't know about? Could there be more? Sure, there could. These attorneys seem to be talking about everything in open court, so I'd be surprised if there was. I don't see us as being there. On Monday's episode of The Emily Show, which I'm going to go work on next week's episode of The Emily Show, we're going to be talking about some attorney behavior the allegations are wild, because we're going to be getting back into the Jay-Z case. Y'all, there is some stuff we need to chat about, but that's going to have to wait till next week, because this week is going to be so busy. But we will start talking about attorney behavior. If you want to look at attorney fuckery, Tom Girardi, Alec Murdaugh, like the fuckery has to be like fuckery. This is not there. So Tony said, you mean Quick Bits? The artist formerly known as Quick Bits, The Emily Show. So we will see. The Craft Witch Rachel said possible defense sanctions feel more like a speeding ticket than anything. Yes. It's a acknowledgement of there was a thing, but also you can get an acknowledgement in a filing without sanctions. So I don't know if we're going to see sanctions in this or not. So we'll see if we do, but I just don't know Massachusetts well enough to give you a read on that. It's a problem. Is it the worst problem that we have ever seen? No. Is it a problem? Yes. What's the remedy for that problem is the question. And I don't know Massachusetts well enough to tell you exactly what the remedy in this case will be. But I think that, an attorney getting kicked off the case is a way out of alignment remedy for what the issue is. So I don't think that that's the remedy in this case, but we'll see. We'll see. This is going to be interesting. I'm interested to see what the court does. I think the arguments tomorrow on the motions to dismiss will be interesting. The standard is difficult. It is not an easy standard for the defense on the motion to dismiss, even with everything that's gone on with the videos. And it's completely unacceptable that the Commonwealth seemingly had these videos in 2022 and is just like, but wait, there's more. It's just wild to me, because that shouldn't be happening. And it shouldn't ever be just kidding, there's more evidence. Just kidding, there's more evidence. It should all be turned over. So how the fuck any of that happened, we still don't know. I'm hoping we hear more about it tomorrow, but we'll see. I want to hear Brennan explain where all of the video evidence has been. How did it not get turned over? Aside from the arguments about it being preserved, how did it not get turned over? It's incredibly frustrating. So it worries me whenever we see new information coming up after a first trial, because would it have ever been uncovered would it have ever been uncovered? I don't know. The investigation in this case was not good. Does that mean I believe everything the defense has said? No, not at all. But the investigation in this case is not good. Ralph said, how do they not get sanctioned for that though? Well, that's what the motion to dismiss is. The motion to dismiss is actually asking for the sanction of dismissal. They're not saying sanction the prosecutors. They're saying dismiss the case. We don't want you to just sanction the prosecutors. We don't want you to just keep the video out. We want you to dismiss the case. That would be that remedy. So they are asking for a sanction. They're not asking for monetary sanctions. They're asking for dismissal as the sanction. I hope that makes sense, that they are asking for it in a different way. And that's what we saw in the Baldwin case. The remedy for the discovery issues in the Baldwin case were the dismissal. The prosecution wasn't sanctioned. Oftentimes, the issue with a discovery violation is to turn over the discovery or give somebody more time. That's often the remedy. That remedy might not exist here because no matter how much time the defense has, it still doesn't bring back metadata that may have been lost within those first 30 days in 2022. It doesn't bring any of that back. So we will see. I really hope that on the motion to dismiss, there's an evidentiary hearing, and that is purely for me. I do think it's the right result, but also I want to know. How did this happen? How did videos get lost? How did this all go down? And I think an evidentiary hearing on those topics is the right result. And again, that's what we saw in New Mexico. The court said, you know what? Let's have an evidentiary hearing. Bring everybody in. How the fuck did this happen? Explain it to me. And I think that's the right result. This might be the regular practice in Canton. It shouldn't be, but it might be every time there's a video that comes in, we just drag and drop it. That's always how it is. That might not be, it'll be a problem going forward, but it might not have been out of alignment with what they were doing at the time. And I think somebody needs to come in and explain it. And we'll see if they do. We'll see what the court rules. So, I was clapping. That was me. We'll see. But I got questions. So we're going to be in court tomorrow, 11-ish Eastern. So know that we will set a time for the stream based on when we think court will start. And then we will bump that back if court gets bumped back. The best way to know when court starts, because we're going to make sure that we send out the Law & Nerd notification when court starts so that you guys know. But court should start around 11 a.m. Eastern, 10 a.m. Central. I imagine it will be a little bit later, but we'll see. Law & Nerd app at lawnerd.app.com. And we will go to court when court goes to court. But remember, the defense will be in federal court. If we have a summary from social, I will give you guys a summary of what happens in federal court. But what's going to happen in federal court tomorrow is they're going to argue the motions that we've covered and be asked questions about them. Without watching it, it's hard to know. It's hard to know which way the court's leaning. And with appellate courts, sometimes it's really hard to know anyway, because everyone should be questioned vigorously. I don't know if we'll have a ruling on that before trial. I hope we do. It would help. So we've got a lot pending in this case and a long way to go. A short time to get there. So I'll see you guys on stream tomorrow. Get the app. I'll see you. Law Nerds, you're the best. Best research attorneys around. We've learned all kinds of new things today. And we finally heard the attorneys talk about the federal investigation in court. So who knew? All right, y'all. I'll see you tomorrow. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerd.app.com. It's a free download on iOS and Android, so I can keep you in the loop, because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.